Mr. Chairman, we're live on YouTube.
Excellent. All right, well, welcome back, committee. Welcome back, public. This afternoon, we're going to be looking at a single topic, which will take us through the remainder of the day, and that topic is juvenile justice. Before we jump into that topic, I should have done this earlier, but we have some new faces to the Legislative Service Office who are assisting us here today and in the future. And our senior staff attorney, Mr. Fuller, I would ask if you could just introduce all those new faces to us.
Sure thing, Mr. Chairman. So I'll start across the room. First is Pierre Chenet, who is a new research analyst. He graduated from the Utah Valley University and then completed a master's degree at Indiana University. And then next to me is Emily Wangen. She is a new legislative editor, and she'll be kind of the primary point person and our staff person for Judiciary now. She is a recent graduate of the University of Iowa. And then, Mr. Chairman, members of the committee, I hope they're up there, but we have two new staff attorneys that I'll introduce as well. Anna Johnson comes to us from the Public Defender's Office here in Laramie County. She graduated from the St. Louis University Law School. I believe undergrad was University of Minnesota. And then Lucas Plum, our other new staff attorney, graduated from Coe College. He is a University of Wyoming College of Law graduate, and he comes to us from the District Attorney's Office here in Laramie County.
Fantastic. Well, welcome Pierre, Emily, Anna, and Lucas to the best committee in the Wyoming legislature, the #1 committee, Judiciary. All right, with that, we have, if you are paying attention to your agenda committee, you'll see that we do have a series, and if you paid attention to the materials, we have a series of memoranda that were prepared by our LSO staff and Mr. Fuller. And I'm not going to have Mr. Fuller read those in for us, but you have those materials. They will probably be teased out throughout, at least portions of them will be teased out throughout testimony and this afternoon. But if you have particular questions about the memoranda that you received and would like to ask any of those questions, I'll certainly start with that. Otherwise, we'll move into our testimony. So if you have any questions on what Mr. Fuller prepared, now is a good time. And it's right after lunch, so it's actually a bad time to ask the committee to ask questions. All right, you're on deck.
Good afternoon. Thank you for having me here again. I'm Michelle Feldman from Council of State Governments Justice Center. It's really nice to be here in person. It's felt like too many Zoom hearings, so I'm happy to see you all face to face. And when I was here last time, we talked about fair chance licensing and the impact that a juvenile record can have on a person's ability to get a license to become a professional well into their adulthood. And I believe that Dr. Ben Moritz is going to be here to talk more about how that impacts community college students. But a professional license can be a pathway to good paying jobs for people with criminal records. And there is a huge need for skilled workers, including licensed professionals right now. So I thought this report was very interesting and relevant from the Wyoming Department of Workforce Services. This is their August report, and they reported a 5.5% unemployment rate in the state, but there was also a record high number of job openings, and that is a real mismatch. You usually don't see that. And the report suggested that one of the reasons is that there's a need for skilled workers that businesses have that this unemployed population isn't meeting. So that really kind of highlights the importance of right now addressing barriers to occupational licensing, especially for the huge pool of untapped talent that is the population impacted by the justice system. And this is just a slide that shows some of the barriers to licensure that people with records face here in Wyoming. So there's 150 different provisions of state law that can restrict a person with a record's ability to get a license in their chosen field. 20% of those restrictions are mandatory. So no matter the circumstances, if they committed the certain offense, they can't receive the license. And then 85% of those restrictions last for at least 20 years. So even a crime that was committed as a teenager, it could impact a person for the majority of their adult life. And the legislature did take significant steps to improve fairness in licensing for people with records. There was a law passed in 2018 that kind of did 4 best practices, which are a good start. So first, it says that boards shall not consider prior convictions that don't affect the practice of the profession. The problem with that is it's really vague and not providing criteria that has been helpful in other states for boards to make that determination. The law also removed for some professions disqualifying phrases like good moral character, but there's still vague disqualifiers in existing professions in the administrative code. And the law also says that boards may cite specific factors as public policy, including the relationship between the offense and the profession, whether giving the person the license would give them an opportunity to reoffend, and if there's an opportunity to appeal. And then finally, it puts a 20-year limit on boards' abilities to consider crimes that are not related to the profession. So this is really a foundation, but there's still broad discretion for licensing boards to deny a person based on any criminal record, regardless of whether it poses a public safety threat. So for example, over 20 licensed professions, you can be excluded for any felony. Over 15 licensed professions, any misdemeanor that relates to the occupation can lead to a rejection. And the real problem is not that it's happening in practice. And we spoke to the Department of Administration and Information Services, which provides support to over 20 licensing boards. And they could only recall a handful of applicants that were rejected because of their records. But what that number doesn't capture is the deterrence effect. How many people are going to go through the training and pay money to pursue an occupation only to risk being denied a license once it's over? And this is just one example. So if you wanted to become an athletic trainer, you need to go to college for 4 years. You go to University of Wyoming, that's about $17,000 a year. But you can be excluded for a conviction of a misdemeanor that involves moral turpitude. That's not really clear what moral turpitude, what that falls into. So is somebody going to take that risk when at the end of the day they can be denied the license? Probably not. So there's kind of 3 buckets of best practices that we're recommending that have been implemented successfully in other states. So the first is pre-application determinations, and that authorizes licensing boards to make an assessment before the person goes through the training and the education about whether their conviction is disqualifying. And that's kind of the key reform that addresses the deterrent effect. And 19 states have implemented it. And it's really kind of a factor that allows people, especially college students and others, to know what career pathway to pursue. So the second one is just really honing in on the language and kind of making it more detailed about the individual factors for consideration. And the current law, it does acknowledge those factors, but it's more of a policy statement than a requirement that boards consider these certain factors. So this is just a map of states that require every applicant with a criminal record to be considered on an individual basis, and that boards consider factors including evidence of rehabilitation, passage of time since a crime, the relationship between the offense and the job and any public safety concerns. And then finally, just addressing that 20-year look back time limit and consideration of juvenile records. So the 20-year time limit, that is for crimes that have nothing to do with the practice of the profession. So if you commit a crime when you're 19, 19 years later, even if that crime had nothing to do with your chosen profession, you can be excluded. So states across the country, they have look back periods that are usually much shorter. It's about 5 to 7 years after the conviction. And again, this is for crimes that are not related to the practice of the profession. And really, juvenile records in practice, talking to A&I, it doesn't seem like they're being considered, but just putting that explicit bar helps applicants understand that, their record, that a youthful mistake, it's not going to be used to exclude them. So these are kind of the broad reforms that we, CSG provided the committee with a potential draft bill that incorporates some of these, and just kind of some other tweaks like written notification of denial and explaining the reasons why, more administrative things. And that really sums it up, and I'm happy to answer any questions.
Committee? Ms. Feldman, on this, so just looking at these different, there's really 3 options that you're looking at that are, we call them reforms. The last one that you just spoke about is the one we addressed primarily in 2018, or the last bill. I can't remember if that was health or corporations. I think it was health. The second reform, require individualized consideration of all applicants, guided by a consistent factor-based analysis. What conversations have you had with our stakeholders? So you mentioned A&I as an example.
Yes.
To know that, I guess, statutorily or procedurally, is our law or rulemaking the opposite here, where it does not require individualized consideration? I assume it not to be. And if not, then do we know that we're not doing this?
Thank you, Chairman. That's a great question. And A&I, because they're a state agency, I don't want to speak for them. And they asked, that they said that they'd be happy to testify. I think the general notion, so we spoke to the Business Association, we spoke to the Community College Commission. I think the problem is there's no consistency, there's no uniformity across all the boards, particularly because they're not all under one unifying agency. So it's going to be up to the boards how they kind of interpret what that means if the crime is related or directly related to the practice of the profession. And that's really where those individual factors come in. So it's looking at the person as a whole, not just a crime that they may have committed, decades ago, seeing what steps have they taken to rehabilitate, what is their work history, have they committed other crimes since? That really gets into the public safety question. And that's kind of where, the difference is between the current law and what we've seen in other states.
So Ms. Feldman, sort of asking every board to come in front of me and answer that question. Do you have a general idea of how many of our Wyoming licensing boards have a policy in place, whether written or just in practice, that would, for lack of a better word, arbitrarily exclude applicants because of a certain offense or history in their, or nature in their history?
Thank you, Chairman. So there is a really good resource that I had sent to the committee staff that the Office of Workforce Development kind of outlines criteria for each licensed occupation in the state. And you'll see in that, like the athletic trainer, kind of requirements, these generalized terms like if you had a misdemeanor involving moral turpitude, you're out. And that kind of leaves the question. So I think what you're raising is kind of underscoring the problem that there isn't consistency, and A&I didn't have a uniform written policy as far as I know. And boards may have that, but certainly not. There's 97 licensed occupations in the state. So, there's really a lack of uniformity about how to look at criminal records. And it's particularly challenging because criminal justice, most boards are not experts in that and shouldn't be expected to be.
And I guess the conviction of a misdemeanor involving moral turpitude is a good example, although I can see it providing both lanes of opportunity. I can see it providing or having it not defined could provide for individualized consideration from the board, because say if it doesn't have a blanket policy that says every kid caught with a gummy with THC in it is excluded from licensing versus no one's doing that, says co-chairman. But no, that's the point though. Even if they had that policy, that's what provides them, isn't the lack of the definition what provides them the discretion to figure out for their individual board, okay, this is the type of behavior we wouldn't see among our professionals, so we would limit it. So defining that or making it more stringent, couldn't it have the opposite effect?
Thank you, Chairman. That is a question that, at CSG, we've kind of evolved our thinking on, because originally we had been proposing that states list out the specific crimes that are disqualifying for every profession. But what that turned out to be was just endless lists, just out of an abundance of caution. So the kind of big picture and what has been recommended, at the federal level and, implemented by other states, it's looking beyond just the type of conviction to, all the other factors that make up an individual applicant. And, rather than reflecting on where they were, assessing where they are now. So, a crime, if it was a misdemeanor of moral turpitude, rather than kind of having that limited exclusion, really doing an assessment to take into consideration other factors.
And one last question then, on the requiring individualized consideration of the applicants, if that is the practice, let's say, then enacting or dealing with the statute, and I don't remember what Practice Act, how it deals with this, but I would assume the difference then, if it is the practice that is already occurring around them, would be creating what, a right of action if it was arbitrary. But maybe this is a legal question, maybe for you, maybe for somebody else, but wouldn't that already exist if I could prove that I was arbitrarily? And Co-Chairman Nethercott says yes. Wouldn't it already exist that I would have that right of action if I could prove I was arbitrarily denied because I was grouped instead of individualized?
Thank you, Chairman. I think the answer is yes, but I don't want to, I think other people can probably answer it a bit better. The individualized consideration, kind of the key link to that is the specific factors. That's how having those criteria is what makes each individual be carefully considered for, their entirety. So there is, in this law, the 2018 law does provide for looking at applicants on an individual basis. The problem is that there's not guidance or standards about how to do that.
Co-Chairman or Vice Chairman Washington.
Thank you, Mr. Chairman. Just so I'm clear, we're talking about juvenile justice this afternoon. So are we talking about acts that were adjudicated delinquent in juvenile court, acts that were adjudicated in municipal court, or crimes that were transferred to adult court, or all of the above? What are we speaking about here?
Ms. Feldman?
Thank you, Chairman, and thank you, Representative. So it's really just an explicit bar on any kind of juvenile record. So I think that would probably be all of the above, using that to exclude people or, to take that into consideration. What we often find, especially with, youth offenders, is that they overshare the information because they don't want to be seen as, hiding something from an employer or a licensing board. And sometimes that works to their disadvantage. So just putting explicitly in the law that this will not be considered, that's another way to get at the deterrent effect.
Thank you, Mr. Co-Chair. Just a few questions. I guess I need to hear more about the number of people. I understand what you're saying is there's a group out there is you can't determine because say they didn't apply, but we're not dealing with that right now. We need, I would like to know what the numbers are. Say, forget the COVID-19 era because we can't really rely on anything there. Let's say from 2017, 18, 19, the past juvenile crimes that I guess happened and then said denial of a position. Could you share some information with that, please? Thank you.
Thank you, Chairman. Thank you, Senator. So when we spoke to A&I about possibly getting those numbers, that's not something that they keep track of, and the boards that they oversee, it didn't appear that, they're tracking that data. So there's really no kind of record of how many people with criminal convictions are being rejected. But again, we do know from other states that have implemented reforms how many, once they've done some of these reforms, like North Carolina in 2019, about 5% of their applicants were people with records. And, after the reforms passed, less than 1% were rejected. And it really kind of gave clarity to both the boards and the applicants. But unfortunately, there isn't data, and that is a possibility to include in a law is, having the boards report that data. Some states have done that.
Senator Cole.
Okay, thank you. The issue I find though is how do I know that there's a problem? We can make assumptions and say there must be because of this data. Well, we're here in Wyoming and I don't really know. And then you run into the problem with these boards doing their due diligence and they're going to hire staff attorneys. I mean, there's a bunch of other ramifications that happen. I think, the moral turpitude is a rather good word. I mean, sometimes law is written in a way that's broad and sometimes it's not for particular reasons. But without data, I just have a hard time understanding what the need is. So thank you for your testimony.
No follow-up. I mean, that is the whole problem, is the lack of data. We don't know the impact of the problem because people are not even starting those career paths because they don't know if they'll get a license at the end of all that investment. So that is kind of, the underlying problem.
Sometimes I just think about the association that gave me a license. All right. Questions any other questions for Ms. Feldman? No. All right. Well, thank you for kicking this off for us. Dr. Moritz is going to talk to us from the Community College Commission. And you were mentioned in Ms. Feldman's, at least your association was. So I don't know if, well, I'll call you back up if we need you, Ms. Feldman. You can stay up there if you'd like. May open up the floor for more questions. Go ahead.
Well, Mr. Chairman, thank you for having me here. I won't take up a lot of your time. I'm happy to provide additional information and context around how this impacts the community colleges. I have been surveying the VPs of academic affairs at the different colleges to learn more about their policies. and which academic programs would be impacted and, well, are being impacted by criminal record requirements. And so I can provide just a little bit of overview. And I should say at the end of the day, we have the same issue that was mentioned earlier, that the colleges are not tracking people who don't apply because they don't know if they can finish the program due to a criminal record that they have. So it's difficult to ascertain something that isn't measured. Most of the programs that are impacted are either in education, criminal justice, the health fields, or information technology. And the most restrictive requirements would be in the health fields. And in most cases, well, I should actually take a step back. In all of these cases, the colleges are not imposing these restrictions because of their own internal policies. Rather, they are not allowing students to begin a program that leads directly to a licensure that they would not be eligible for. And if they identify a student who is interested in a program, that student acknowledges that they do have a criminal record, and the college identifies that that would prohibit them from getting that licensure. They do tell the student who the licensure board is, if there are any ways that they can apply for pre-authorization, and encourage them to do so. But the anecdotal information that I received from talking with representatives from the colleges is that they would rarely see those students come back and then apply. Again, it's not measured in a statistical way. That's more anecdotal.
Sorry, can I ask you right there though, Doctor, because I understand your concluding statement that it's not measured, but do you have the measurement of at least the number, an idea of the number of students who would go before whoever they're talking to at the college and know that they may have that issue?
Mr. Chairman, I don't have a specific number. From those stories, it sounds like each college is dealing with a handful of students. One of the other issues is that sampling suppression would probably come into play if we did start tracking that, simply because we have a small population, the colleges are relatively small, and this is spread out across quite a few different programs. So one of the examples that was provided was radiography. Radiography is, maybe dealing with 10 or 20 students applying at a particular, well, perhaps across the state. I don't have the exact numbers. And so if one or two students in a given year were to approach and not come back, that would be a substantial percentage, but from a aggregate number, it would be quite small. So I'm really hesitant to say more than a handful in these different areas.
Thank you, Mr. Chairman. Do you know if these program areas you're referred to in health and criminal justice and education, are those programs low on enrollment? Would potentially allowing folks with criminal histories to enroll in these programs, would that fill slots that are going unfilled now? Or like a radiology program, is it already full?
Doctor?
Mr. Chairman, Representative, thank you. That's a great question. It varies widely. The education programs, that's one of the areas where a criminal record could impede your ability to pursue that. There is a fair amount of space and availability in those programs. However, in the health fields, those that are restricted, especially by clinical placements, there's a long waiting list across most of the colleges. And then if you go into IT and criminal justice, those are going to be somewhere in the middle. So some programs, if you allowed students in, it could fill up spots that there are waiting lists for. In other programs, it would probably allow the colleges to fill spots that otherwise were not being filled.
Thank you, Mr. Chairman. Dr. Moritz, appreciate you giving testimony. So if the community colleges also do this determination to basically let a student know that they may or may not be able to get a license, would it, given that the community college might have a different interpretation of the language that's in the statute versus a board when they make a determination on a criminal record, would it help the community colleges with those applicants if there was a predetermination program for all licensures? Thank you, Mr. Chairman.
Mr. Chairman, Representative. It's probable that it would make it easier for the colleges if there were more pre-authorization programs out there for the different licensing bodies. Those licensing bodies that have less well-defined processes to obtain that pre-authorization, it's more difficult to communicate what the student would need to do to those prospective students. And so it does provide a difficulty. When I was looking into this, I started with the vice presidents of academic affairs, but the programs get down to a granular level quite quickly, where you have, one person running one instructor running the radiography program. You might have another one running the health info technology and management program. And so they're each dealing then with many times different licensing boards themselves. So as professionals in those fields, they stay on top of what those requirements are if those were to change. And so they are well equipped to answer those questions. But I see your point that the less well-defined those requirements would be, or how that pre-authorization would be obtained, the more difficult it is for the colleges to communicate that to the students, and one could assume less encouraging for the student to pursue those. If that answers your question.
Senator Cole.
Thank you, Mr. Chairman. Just a kind of a follow-up on that last question. Would it help to have a pre-application process that you would apply to a board to see if the board would outright reject that applicant because of some background issue beyond the scholastic achievement that they have not yet attained? Some way of getting a pre-approval. And maybe we could put some sideboards on just what the issues may be with the pre-approval process, just as a throw out there as a thought. Thank you, Mr. Chair.
Mr. Chairman, Senator. Yes, that would be helpful. And those do exist with some licensing boards. As an example, the Professional Teaching Standards Board has a process for prospective educators in the state to submit their criminal records and make an application and provide any narrative that might provide support their efforts to ask for an exception. And then the PTSB will review that and provide that feedback before the student begins that education program. As was mentioned before, that's a 4-year degree, and it can be quite expensive and quite an undertaking of time and money. And so within Wyoming, the PTSB has established that way to vet ahead of time a student's criminal record to make sure that it does not impede that student's ability to teach in an educational setting. Just as one example.
And, it just now clicked for me, Senator Kolb. I have a little bit of familiarity with this because I recently had received an email from the Texas Bar Association for fitness and character reference on an application. I was really confused. It was for an intern that I had, and she just started law school at the University of Texas. And I was really confused about why she would be applying 3 years early. But that's the process that you're speaking about, is that wherever that fleshes out in Texas's process, she would know whether she would ever be licensed, or at least whether she has a good shot at being licensed, and could make that decision now in law school, which you could figure that out 3 years in advance, not spend those 3 years in law school. I suppose that both financially and just time-wise is an interesting change in your investment. If that's what you're speaking about, is that that possibility? And that is that's one of the recommendations that Ms. Feldman, you were talking about. That's the pre-application determination. Okay, go ahead, sorry.
Thank you, Mr. Chairman. That's the bulk of the information that I have. And I should also say that, this is based on discussions with the 7 colleges. Each college is independently accredited and overseen by their own board and establishes their own policies. And the Community College Commission, for which I speak, is a coordinating body. However, there is the policies adapted by the 7 colleges are very similar. All of them are interested in enrolling as many students as they can and providing for workforce training as is part of their mission under statute. And so if there is a student who was able to pursue a particular program and was not prohibited from getting the licensure or going into the job field that prepared them for, they would be very interested in allowing for that student to do that. And it's only when they know that would be a prohibition for that particular student based on their record that they would deny entry into the program. I had a few more examples of different areas that different fields of study that were impacted. It's a short list, but I don't need to go into that now unless would you? Okay. Paralegal is one of those areas. Education. The information technology degrees include data center technologist, cybersecurity, various Microsoft and Linux certificates. And the reason for those IT degree requirements are because of the security involved, and that these people, when they get that certificate, would be expected to secure IT systems. Within the health fields, it includes dental hygiene, diagnostic medical sonography, emergency medical services, health info tech and management, nursing, physical therapist assistant, radiography, speech language pathology, surgical tech, radiography, and finally, commercial driver's license. And the aspect with that particular one is if a student has more than 2 DWIs, they are not allowed to get that certificate at any point. And that's again, a board level policy or a state level policy. And there may be additional ones. Not all of the 7 colleges gave me a complete list, but going through the programs that we have seen have been approved, I believe this to be the majority of the programs.
As Representative Zonitzer.
Thanks, Mr. Chairman. Completely off topic. When do we start saying there are 8 community colleges instead of 7?
It's a slip of the tongue. We have 8 community college districts right now.
Didn't even catch that. Committee, additional questions for the Community College Association? So just, you've given us some anecdotal data points, some ideas of what we're actually looking at. I don't know if, and I don't necessarily, I guess, care if you have reviewed the draft legislation because that wasn't prepared by our office, but I'm just more curious. Generally, it seems like you spoke in favor of some pre-application determination process that could be beneficial to students. Do you have any other opinion about the other reform measures that we've been talking about? Or even about the legislation, but I hesitate to spend too much time on the legislation because I think it's just a conversation starter is really what it is.
Right. Well, the community colleges work closely with Department of Workforce Services, work closely with industry across the state, and we are all keenly aware of the disconnect between unemployment rates and at the same time job shortages. All of the colleges have advisory boards where they work with their local industry. And the message that we're hearing again and again, and I'm sure all of you are as well, is that there are not enough qualified people either interested or available to take the work that is out there. I personally just came from the Wyoming Workforce Development Council meeting out in Afton, and that was, I would say, probably 50% of what was discussed was related to that. How do we bridge that gap? And so job training and workforce training is core to the mission of the community colleges. And they're very interested in especially reaching out to working adults or non-working adults who may need upskilling to be competitive in the market. And we are aware that there is a proportion, I'm not exactly sure what that proportion is, of those working adults who have criminal records and are either precluded at this time or are dissuaded from pursuing additional training to get back into the job, into the workforce. And to whatever extent, in a safe and overseen way, appropriate people who have the skill set and the interest in work and would be appropriate for the various workforce areas have an ability to go back into the workforce. That's in my perspective, and also through the colleges, I think that's in everybody's best interest. So the other two main components that were addressed earlier definitely seem to play into that. And any increase in the workforce that's eligible to go back and get workforce training is going to be the community colleges and the Community College Commission are going to be in favor.
Representative Provenza.
Thank you, Mr. Chairman. And Doctor, I'm wondering if in the conversations with the different community colleges, if the issue of expungement ever came up, or like informing people who came in maybe with a juvenile record that they could expunge their record if they didn't commit a violent felony, or for adults, the various implications there. So was there any understanding of that, and are we communicating that to students or prospective students?
Mr. Chairman, Representative, that did not come up in the discussions that I had had. I do know that working with previously incarcerated individuals in particular has been one of the areas that several of the colleges have looked into. That doesn't specifically address your question, and I did not ask that particular question.
Senator Kolb.
Thank you, Mr. Chairman. I had a question back on the CDL DUI situation. I guess the question is that train driven by the insurance companies that won't insure somebody if had multiple DUIs with the CDL? Or is that you folks, as educators, not wanting to educate somebody in a field where they couldn't get a job because of the background? And where's your line there between what you do and don't do, or look at and don't look at? Thank you, Mr. Chairman.
Doctor, do you have an answer for that?
I do know that they cannot get their commercial driver's license with those DWIs, or I believe it's DWI as opposed to DUI. And so it's not a decision made by the colleges. It's simply they won't start a program that they know the student cannot get the certificate in. The role of the insurance companies is it's unknown to me.
Ms. Feldman, do you by chance know the answer to that question? Is it a federal law? Federal law. Trust. Co-chairman Edicott. Ms. Feldman or Dr., either one of you can answer this, but on the pre-application process, and I imagine if we were to entertain that type of an idea, I would definitely hear from all the licensing boards. But I think the one thing I know that I would hear from the licensing boards, we would hear from the licensing boards is that, most of them don't have a professional staff. And if they do, they have one executive director for the office. And so most of those decisions on those licensing boards are made by volunteer professionals who give their time. And my question is that going to cause more work? Or is it the same amount of work because they're just making the decision sooner? What does it look like in these other, I think it was 19 states you said that have the pre-application?
Thank you, Chairman. In other states that have pre-application, it's pretty minimal. There's no flood, particularly because applicants have to pay a fee. So that's kind of if they're not serious about pursuing that career, they probably wouldn't do that. But I mean, that's a great thing about A&I here is that they do provide administrative support, to some of the licensing boards. But I think you're also right that they're either going to do it upfront or at the back end. It might just be a few more applications, but there's never been an overwhelming amount in these other states.
Vice Chairman Washington.
Thank you, Mr. Chairman. My question for the community colleges is, might there be a way of publishing like an FAQ type statement for each of these areas where we have high refusal rates or potentially high refusal rates that helps spell out the kinds of crimes that would be disqualifying and the types of crimes that would not, rather than tying up our volunteer board members and so forth with a lot of time-consuming evaluation on a case-by-case basis. Maybe we could get something a little more general that would be applicable to a wide array, and then we'd have some consistency from community college to community college.
Thank you. The colleges, right now, it's not listed on each of the websites for the programs. I believe what pretty much all the colleges do is list something that says admission criteria for individual programs varies. Please contact the representative for that area. The representative for that area, as I had mentioned before, these tend to get very granular as you get into these smaller and smaller programs. And so that's going to be a particular instructor, and that instructor would, through a face-to-face or email or a phone call, would walk a student through those because they are familiar with what types of crimes would preclude them and which would not, and which could be eligible perhaps for a pre-authorization or an exception to be made. It's generally based on their experience and their experience in the profession. For instance, in radiography, for instance, the instructors there are in that field, and so have been in that field for long enough that they know which types of felonies would preclude a student and which ones might be an exception might be made for. It's that information could be compiled and shared as a resource, and the commission as a coordinating body frequently does things like that, where we're compiling information just as I did to provide to all of you. So what it would do in essence is change that from a individual conversation to a student being able to look at that long list on their own before having that conversation. If that's what you're getting at. If it is, that does not exist now, but could conceivably be put together with some time and effort.
Co-chairman.
Thank you, Mr. Co-Chair. So I think the committee is intrigued with the idea of kind of the pre-application determination. Sounds like that's where we're at, that there's further discussion. But when you listed some of the programs that the college has communicated back to you that they've seen some of those questions or inquiries, I'm familiar with the licensing boards or the certifications associated with some of the more traditional occupations, but the new kind of IT or data center and those types of occupations, there's not a licensing board to get over data center certificates. Am I wrong in that? So I just want to make sure that we're being very clear about what occupations we may be providing solutions to and which we are not.
Yes, Mr. Chairman, Senator, that's true. Those are third-party certificates. In the case of Microsoft, for example, it's Microsoft Corporation that puts those out. And they are not a board, they're a company, and I don't know what their administration is for providing and reviewing those criminal records. So if there were change to the statute to allow for pre-authorization for boards, it's true that that would not cover that. That could be a differing category.
All right. Thank you both. Do we have anyone in the virtual world signed up on this topic in particular? I don't think so. Yeah. Well, fairly, yeah. Maybe.
Yeah, Mr. Chairman, we don't have anyone for this subtopic, for the fair chance topic.
We don't have isn't that Mr. Bohan plus? Mine says agenda item 4, fair chance licensing. Kevin?
Yeah, Mr. Chairman, he's here in person.
Oh. And signed up virtually. Which one do you want? Okay, all right.
Mr. Chairman, members of the committee, my name is Kevin Bonnerblust. I'm the Executive Director of the State Board of Medicine. And I guess my main message to you is my board's not even really looked at this. And so it's not a yes or a no, good, bad, or indifferent, but rather kind of a tap the brakes, if you will, because I commend CSG for talking with ANI. They administer a bunch of the small boards. But so far, nobody's talked with medicine, nursing, pharmacy, real estate commission, all those professions that really, a lot of them need this sort of tool in their toolbox. So I would suggest that, with all due respect, this be taken the kind of a deliberate step. I did want to point out, as co-chairman noted, some of those professions, paralegal, IT staff, commercial driver's license, those aren't licenses issued by the boards. And so this proposed legislation wouldn't affect them in any way. But again, not to say for or against, but just to give you a few ideas. First off, when a licensing board denies an application for a license, you're required to produce a formal document after having gone through due process. The applicant gets to present their case, why they should be licensed, and then any opposing party can say why they should not be licensed, and then the board makes a determination. If the board determines to deny, then they have to issue an order with findings of fact, conclusions of law, and then the order denying, which is then appealable under the Administrative Procedures Act to the district court. So at that point, then you've got a district court judge looking at what's going on at the board. And I will tell you from personal experience, our district court judges are not shy about saying, we don't think you had adequate cause here. And it's happened to my board, it's happened to just about all the boards. And so we really have to do our diligence. So it's not accurate to suggest that there is not some sort of recourse for someone who's been told you can't have a license. I will tell you, for instance, in the Medical Practice Act, up until 11 years ago, a felony conviction was an absolute bar to licensure. That was changed. We got that changed in 2009. And since then, my board has licensed people with criminal convictions. Worst one I could think of was vehicular manslaughter. It happened in somebody's youth, basically. And all the things they've done since then were taken into account. I suspect had my board said, we don't want to license you because that, I suspect a district court judge would have explained to them otherwise because it just didn't really have any relevance at that point. So again, you have to be able to support why you made this decision. Just because somebody has a criminal conviction is not grounds enough. It has to be related to why you can't safely and skillfully practice that profession. There are the three legs of what was being suggested: the predetermination, the individual
Hey,
determination.
Kevin, before you dive into that,
Yes, sir.
let's talk about that first point.
But
I think definitely for the lawyers on the committee, they understand that process exists, and thank you for clarifying that for the non-lawyers or people who may not have been experienced with that process before, but I think there's also something to be said about that process. Wouldn't you agree that that's an expensive process? As a lawyer, I appreciate that process because I collected an attorney's fee to take that appeal. But just in comparing, and you may have been getting ready to get into this on the three legs, the pre-application determination as an example, for a person attending community college or even a young law student, whatever it may be, the couple $100 that they pay for that application fee to figure that out is far different than what they would have to pay to go through that appellate process. So I'm curious on the one, if you would agree that there's at least some benefit to that, to our, at least to the people of Wyoming. But two, I'm really curious about the pre-application determination in general. And it's not a new idea, so I'm just curious whether your board has ever thought about it or looked at it for your particular licensing area in the past.
Sure. Thank you, Mr. Chairman. I will tell you that I regularly get phone calls from people saying, okay, I've got this in my history. What are my chances? And I'm always very careful to say to them, here's what I've seen the board do, but I don't make those decisions. My board members do. I work for them. And so I never predict. I just say, here's what past history has shown. And I agree with you that is a drawn out process. It's one that courts have said we have to follow. Do I like it always? No, but it is a constitutional protection that we follow. I like and my board has never discussed a predetermination, a formal type predetermination. Those phone calls we'll always answer. But then getting to something where somebody has a piece of paper says, well, the Board of Medicine says that this conviction will not stand in the way of my getting licensed. The concern I have with that, and this is why I think we need to tap the brakes a little bit here, is just to discuss this with the AG, because I think you're setting up a possibility where court will say, hey, wait a minute, you told them you were going to give them a license, but now you're denying it. Are you stopped, or is there something that's keeping you, have you already made a commitment? And so it concerns me what the due process ramifications are, and I just don't think those have been fleshed out. We're very protective of that. So
No, that's a great point. I don't think we'd have to look very far to find that answer. There's 19 states that do it. We wouldn't have to get a full AG's opinion necessarily on that. I think that's why I'm asking if your board's ever looked into that process, because I think, I don't know enough about what those other 19 states actually do, but I'm sure they asked themselves that question. And I'm sure they've had both scenarios where they have said, yes, we would give you a license, and then they didn't. And they've also had the scenario where they said no, but they probably would have, at the end of the day. That one's a little bit harder to appeal on, but I think, so I guess you've already answered my question, which is that you haven't looked at the pre-application determination, but just other than this due process concern, is there any merit to it in I'm talking about your licensing board in particular, or is the phone call, do you feel the phone call vets enough of those, or?
In my personal experience, Mr. Chairman, I think the phone calls handle that sort of thing. I can't speak for every other board, I don't know the other professions, but we always try to say we've got an open door. We're going to listen to you. We'll tell you what we can. And I think that's kind of the Wyoming way with most of our boards. I think you get down to it, most of them are pretty good that way. Something more formalized, like I said, the more formalized we get, the more concerned I am in giving somebody due process. And so that's something I would like to flesh out further, including those 19 states. What have they done? What do they have in place? Because you don't want to tie the board's hands in the future. And then again, you also don't want to prejudge. And that kind of takes me into the second point. And because we have to issue those findings of fact and conclusions of law, those are tailored to that specific applicant's situation. So it's not like they can just say, we always deny on this basis. It has to be tied to what that's going to do to their ability to safely and skillfully practice the profession. So I think that's covered to a great extent already just by case law in Wyoming. And then last, the look back, I noted that I think healthcare boards were left out of the look back, shortened down to 7 years. But I would caution you with that because we had a licensee before my time that spent 25 years in Rollins for sexually assaulting patients. And one of the first phone calls he made as soon as he got out was he called the board and asked to go ahead and apply for reinstatement of his license. Now, if you can't look back that far, what do you do with somebody like that? I think you don't want to unintentionally tie your hands and set yourself up with a bad situation. So I urge caution with that. So again, Mr. Chairman, all of that is to say, I just would suggest we have a little measured conversation, talk to some of these boards, and let us talk to our board members and see what we can do.
Yeah, and I'm with you on that last point. I kind of alluded to that in this earlier testimony, that at the end of the day, you all are the major stakeholders that hearing from all the various boards on how that might fit into your universe. I think, just where we're at, exploring an issue that there's at least somewhat of an issue that exists. How deep the issue is, we don't know. Trying to find creative solutions to Senator Kolb's point, but not doing something for nothing's sake. But I think where we're at is where you want us to. That's what we're doing right now, is
Exactly.
hearing from the boards, and that's definitely what we want. Thank you. Questions, committee? Representative Rodriguez Williams.
Thank you, Mr. Chairman. Mr. Baumann?
On and blessed. You can call me Kevin, that's fine.
Thank you. Not a question, but just a comment. I think one of the things that I noticed in regards to your website with Department of Nursing and with the physicians and so forth, with the application process, is the transparency that you provide. It's clearly noted that applicants with a criminal history or a mental health history, there's some sample personal statements, there's a disclaimer, et cetera, et cetera. So you go a step beyond what other boards do to put that transparency out there. And I appreciate that.
Thank you.
Co-Chairman Nethercutt.
Thank you, Mr. Co-Chair. I appreciate your concerns, and I think that your concerns regarding creating the appropriate legal process makes sense, because it's a landmine, I think, for any board to navigate. But when we go back to your example of the young med student who just graduated and was seeking admission, who went through medical school, an undergraduate medical school residency, seeking board admission, and he still was having to wouldn't know if he'd ever really be a doctor because of this vehicular manslaughter charge that he had as what clearly everyone would determine to be a youthful issue, right? And of course he would be admitted because it happened years ago when he was a youth, but he took on that risk, right, of 15 years probably of an educational experience and cost. Is it significant debt? Maybe not with WWAMI, but nonetheless, a huge undertaking with still that weighing over his head, right? Now, would it have made sense to him and any other future doctors that are considering med school to not take on a 15-year risk and an education of which they may not ever be able to come to fruition if they had that predetermination, right? So that young doctor took a really risky decision in doing that, almost causes one to question that judgment about going through all of that effort, knowing that it might not have ever happened because there was that felony conviction associated with a homicide.
And Mr. Chairman, Madam Co-Chairman, I couldn't agree more. But I will tell you this as well. From that case, I recall that physician had no visible ties to Wyoming, nothing that would have told him 15 years before that he's going to be looking at a job in Wyoming, and he needs to check with the Wyoming Board of Medicine to see if he's going to be able to get a license. It's just, the world turns and everything else. And so it's, especially with the higher level of education, the more drawn out it is, I think the more attenuated that becomes and the harder it is to really make an accurate read. I don't have a good solution for that, but I acknowledge that you're exactly right. That took a lot of faith in the future.
Representative Ian.
Thank you, Mr. Chairman. Mr. Bonenbless, thank you. Always good to see you. So I agree that I think it would be premature for us to sponsor a bill draft now, but I think one of the mechanisms that the committee process has is that at our next meeting, we could bring a bill draft and that would alert every stakeholder that we need to have this conversation. So, I mean, do you think that is still too fast, or do you think that would be worthwhile to have a bill draft for maybe just the pre-eligibility determination? So we could all have this discussion and see whether it does make sense with all the stakeholders involved. Mr. Chairman?
Mr. Chairman, Representative, I think it's whatever the committee is most comfortable with. What I'd like to do is say that, licensing boards, I think I can speak on behalf of my colleagues that we would be happy to work on this and help explore some of those concerns we've raised, especially that pre-eligibility determination. Because again, as co-chairman noted, that it's a minefield when you start getting into the due process rights and everything, and we're all entitled to them. We don't want to trample on those. And I'd rather get it right the first time rather than have one of us get overturned in district court and then go up to the Supreme Court and we all get schooled, which has been known to happen on occasion. And so I think that at least to the point of getting the parties together, I would certainly commit to doing that prior to your next meeting and seeing what we can figure out, if we can get some sort of good language that would maybe not make our attorney general break out in hives. So.
Yeah, and Kevin, I really appreciate Representative Ian's question, because when this topic was posted publicly, my phone blew up because the questions were, are you diluting licenses? Are we getting into another Practice Act fight? And obviously, I think narrowing that topic to something that we can discuss that isn't so broad that we can have, maybe that's the better way to approach it, so we don't have a bunch of concerns that we're just trying to narrow it to this area. And maybe, for me, I don't even know that I guess what I want to say is if I'm in favor of creating a bill draft on the pre-application process, I'm in favor of that to explore from the boards what your experiences are and whether it's even a good fit and whether we really have issues that we want to address. So that process is really what I'm interested in, where we get more of you to the table and can go through that.
And Mr. Chairman, I couldn't agree more. It's I would rather work in partnership with you all, and we figure out what's going to work well for Wyoming and will hopefully survive in the courts and everything else. And I'd be happy to do that. And I'll commit to the committee this much, that 2 days from now, all the board executives are getting together. We get together quarterly and discuss various issues. And I will bring this to my colleagues from all the licensing boards and let them know we're being asked to go ahead and put our input in here and give our ideas and that sort of thing. We'd be happy to work with your staff as well.
Yeah, that would be helpful. Thank you. Any other questions, Eddie? All right, thank you.
Thank you very much.
Do we have any other boards who decided to come in today, or we all sent Kevin as our representative? Kevin was the representative. All right. Anything else on this topic? We don't have any other scheduled testimony. No? Okay. Then we'll just press on to another topic. Unless you want to, well, I don't know. Let me pause for a second here. Sorry, committee. We have an entire afternoon of juvenile justice, and we have 1, 2, 3, 4, 5 topics that can produce legislation. So would you prefer to dispense with possible legislation after each topic, possible motions or discussion while it's fresh on your mind? Would you rather try to do all of that at the end on 5 different topics? Or are you just going to leave it up to me to call the shot? Yeah. Yeah. Yep. All right. Well, I've done this enough to know that there are 2 things that happen when it's 5 o'clock. 1, we're always behind. And 2, we're trying to get out of here. So I think discussing all of these topics at the end is going to be very difficult. So what I would like to do is I'm just going to break each topic down as we cross over them. So I'll ask for any public comment on this topic in particular now. I'm not going to save that public comment to the end, although won't necessarily prohibit general public comments. But if there's anyone who wishes to speak on this topic specifically, now would be your opportunity. Donna? And I also need to note, LSO reminded me that if you weren't signed up to speak, make sure you put your information on the sign-up sheet. Is it outside the door? Right outside the door, make sure you put that down for our record.
Mr. Chairman, I just wanted to, Donna Sheen, I'm the director of the Wyoming Children's Law Center. And I had just reviewed a draft bill that was potentially going to be considered. And I just wanted to make the point that it does say it is excluding juvenile court adjudications. And I want to point out to the committee that probably the majority of youth who are prosecuted for crimes who are under the age of 18 are generally in adult court proceedings. So if it's the committee's intent to exclude those offenses, which I would urge you to do, I would encourage you to modify that language so that it incorporates all offenses committed while the person was a juvenile, so that you can incorporate all of those crimes that might be used against them later. And I just encourage you again to consider doing that, because there are an awful lot of collateral consequences that we've now put on youth that really can hamper their future. And with that, I would pause for any questions.
Senator, please.
Mr. Chairman, thank you. Ma'am, would you briefly define your definition of juvenile for me?
I think currently, I guess the term sometimes is used as a minor. So anyone under the age of 18 is legally what's considered a juvenile. However, a juvenile court adjudication can cover a child up to 21, but I believe they have to have committed the offense while they were under the age of 18. So I think juvenile would be anyone who committed an offense under the age of 18.
Follow up, Senator Cooper? No. Committee, any other questions for Machine? Representative Provenza.
Thank you, Mr. Chairman. Thank you, Machine, for being here. Going back to the expungement for juveniles, do you know how many juveniles tend to apply for or petition for expungement? So how many people that maybe are going to be barred from licensing because they committed a felony when they were a child, essentially? Would making that an automatic expungement be helpful in this case, just given knowing how many people are not doing that petition?
Machine.
Mr. Chairman, Representative Provenza, we've certainly been here a number of times over the years, encouraging the committee to consider automatic expungement of offenses that are committed by juveniles. And I would say there's very few juveniles who are aware of that right, or who have the wherewithal and knowledge to go forward and try and do that. So I think it is an ongoing problem. Oftentimes what I see is that juveniles don't know that there's even any problem. They kind of presume that because they were a minor, that's all sealed and confidential. And it doesn't, they don't realize it until they faced being turned down for something. And by that point, it's often too late for them to go through the process. Thank you.
And Machine, just to clarify, and for Representative Provenza, I think, and this isn't my area of expertise at all, but I do remember the Judiciary Committee a few years ago addressing this issue in part with a step that allows the prosecutor to bring the expungement so that it's not solely on the individual. And yes, I guess I haven't checked in on that for a while. I have no idea what the frequency of those petitions are brought by prosecutors. I don't know if you have any knowledge of that.
Mr. Chairman, you are correct. I do think that the legislature gave prosecutors that ability, and it's my understanding that some prosecutors, I know in Albany County, where I sit on the Albany County Juvenile Service Board, that they do that for juveniles who are minors who have satisfied whatever conditions they needed to satisfy, but it is not something that's mandated. So it certainly may not happen in other jurisdictions, which of course is part of our concern about a system that's justice by geography, where depending on where you live, you may have very different rights and outcomes.
All right. Thank you, Machine.
Thank you.
Any other public comment on this topic? Fair Practice Act for juveniles? Seeing none. Close public comment on this topic. And committee, if you have any, if you have any motions you'd like to make, now would be a good time. Representative Yin.
Thank you, Mr. Chairman. I'll make a motion to have a bill draft for our next meeting so we can discuss pre-application determination eligibility for licensure. Using the language, we'll use the starter language to be the language from the CSG proposal, which also has a fee so they can recoup any costs, a reasonable fee, but have it be subject to a discussion with the chairman, with some boards and licensures to make sure that discussion happens before our next meeting.
Seconded by Representative Provenza. So you're the only thing, so we're clear that you're taking from the CSG bill is the pre-application period. And we
That's
should have
correct.
asked Ms. Feldman this question, but of the 19 states that have a pre-application period, is there some type of uniformity in their laws or particular law where it all started and most share, or something we could look at?
Thank you, Chairman. I can send the list of what the specific language is, and I think a lot of it addresses the concerns. It says it's basically non-binding, so it's just to give a person a sense. But of course, if things come up in between where there's not full disclosure, that would change.
But there's no uniform law.
They have very similar language. I don't know if, yeah, there's not a uniform law, but very similar kinds of language. And
Which the CSG bill probably basically takes into consideration.
exactly, yes.
All right. Thank you. Comments? Representative Yin.
Mr. Chairman, yeah, I'll just provide some comment real briefly. You know, I am not totally sure this is a huge population or not. What I do know is that we have a skilled workforce problem in Wyoming. And if this is a population that could become part of our skilled workforce, I would like to keep them from being deterred. And I think the reasonable fee is a reasonable compromise, and especially when we have the language that does keep it kind of vague. And that's, you know, to give leeway to our boards and commissions to make sure that they have the ability to make just decisions for their applications. But I think the compromise to that should be letting an applicant know ahead of time whether it makes sense for them to put in the financial cost of doing all the training before they can get licensed. Thank you, Mr. Chairman.
Thank you. Vice Chairman Washut.
Thank you, Mr. Chairman. I think Wyoming's in a little different place than a lot of other states when it comes to these boards and commissions in terms of how we staff them and, you know, their lack of professional staff and so forth. And I just think that what I've heard today is that people who are concerned about whether or not their past history might be disqualifying, in most cases can simply make a phone call and get that information. And we're, you know, teetering on the edge of making a complicated process that might eventually end up in litigation about whether or not somebody was pre-approved or not pre-approved. And I guess I'm just not in favor of this idea, and I'll be a no vote on the bill draft.
Further discussion, committee? Representative Provenza.
Thank you, Mr. Chair. You know, I can't help but think about this to what I know pretty well, which is jury decision making. When you have ambiguities, people tend to use their discretion to say no, because that's less scary, or to say guilty. And so I think that it would be an important step forward in having things that say that this is what you are supposed to do. These are the instructions, and having less ambiguity. And so I'm in favor of that in order to help with many of the issues that Representative Ian brought up.
Okay. And real quick, just reminding the committee, since we're getting into the process of figuring out how we do all of this. This vote is very different than the vote you made this morning, which was a vote to sponsor a bill. The vote you're being asked to make right now is simply a vote to draft the bill. Representative Craigo.
Thank you, Mr. Chairman. So as Representative Washer was talking, something sort of occurred to me, and I think he brings up a good point, and that is because of the way our boards are structured, they're volunteers on the boards that are appointed. Can one board, let's say at the beginning of somebody's acceptance to law school, med school, whatever we're talking, can their decision, which says, yes, we think you'd be accepted, can their decision bind a future board that may be made up of completely different people? I mean, we deal with that in the county commission realm. I do that at home in my job. I mean, that's something we have to consider on a daily basis, is how can we bind future boards, commissions, et cetera. So I don't know. I'm not opposed to a bill draft. I don't know if I'd be in favor of the bill itself, but for discussion purposes and maybe to gather more information, this helps get us further down the road. And we can get some input from our boards and commissions that we can then actually use to make some good decisions. Thank you.
Mr. Co-Chairman,
Please.
neither for nor against it, but to respond to those concerns. One is, my understanding is the pre-application kind of approval, the conditional or preliminary, agreement for licensure is non-binding. That's a pretty important piece. And the question is, can a licensing board bind future licensing boards? And the answer is yes, obviously, because they consent to the licensure of people in perpetuity until they lose their license in many ways. So I think that's different than the expenditure of funds from a county commissioner's perspective and those types of concerns.
Representative Craigo.
So try not to get into a legalese argument here, but Mr. Chairman, my concern is if these pre-application requests are non-binding, then what's the point? Why don't they just go pay a lawyer $250, have them review their legal background, their criminal background, and say, oh, according to their rules and regs, you would or would not be accepted. And so I don't know what the purpose is if it doesn't have some sort of binding effect.
You meant per hour. Okay, that makes more sense. Yeah, I don't know. I mean, I guess, I think where we're at is that with this discussion is there's a lot of information we don't have. I think we heard from one of the boards that I think this would be most applicable to. When I think of this pre-application, I'm thinking of larger licenses in general that are going to go through that process. I don't know what the 19 states look like, but I'm guessing we're looking at the bigger licenses, medical, law, engineering, things like that. I don't know which area we're actually trying to affect, but based on the community college discussion, it's the opposite end of that spectrum. So I don't know. I could go either way. I think having the bill draft allows those boards to come in and give us more specific data and information. So I don't know. Yeah, go ahead, Senator.
Well, thank you. I had to have a bigger flag. Just in deference to the boards that are a key factor in this discussion. They're not involved. I mean, we haven't really heard from them. We haven't gotten the feedback. We've heard half of the story. Now, not that I'm in favor or against this right now, but without the boards putting in their input about what we're talking about, I don't see how we can move forward. So if the bill was to pass this amendment, I'd move to lay it back and to have the other half of the conversation come in. Thank you, Mr. Chair.
Well, and Senator Kolb, I want to be clear. I think that's the point of the draft, because I'll be honest, the way this came to your topic was a broader topic that had smaller topics within it, and a bill draft from CSG that we posted literally as a conversation piece. And so that's what I've been telling stakeholders who have called me before today. And I think, there's a reason why all the board members aren't here, and it's because we don't have a substantive bill that we're actually considering in front of them to talk about. narrowing the scope to the pre-application period will give, I believe it will give you that. Well, I don't know the outcome, but they will come to the table, they will discuss it with us, but the CSG bill was not, if you remember from our Casper meeting, we only barely touched the topic and didn't spend a lot of time. So, process wise, I think sometimes this happens in committee work where you're midway through an interim and you're inviting the real substance in when you have a real bill in front of you, just process wise, not trying to sway a vote on it, just trying to explain that it's the real bill that brings the testimony to the committee, in my opinion. Representative Yin.
Mr. Chairman, Senator Kolb, I just want to say that I wholeheartedly agree with you. I mean, I don't think that it makes sense for us to pass a bill without their input involved. And that's one of the reasons that it's just a draft. It's so we can have that discussion at our next meeting and make sure that they even have that discussion before our next meeting. So we all come to the table and know what we're talking about at our next meeting, but not sponsoring a draft right now, just drafting a bill so we can talk about it and have that discussion for our next meeting.
All right, let's vote. All those in favor of the draft bill signify by saying aye. All those opposed? That motion has been adopted. All right, now we'll take a break. 10 minutes? All right, 10 minutes. Let's go live. All right, we're live. Welcome back, Judiciary Committee. Welcome back, Senator Cooper. It's the only fun I get to have all day. Come on. All right. All right. Next topic is our boys and girls school. We're mostly just getting an update here.
Good
Should be pretty quick.
afternoon. Chairman Olson, Co-Chairman
Oh,
Nethercutt.
you know what? I don't know if this is still true, but I think it's true that I have to have you sit on the far right end there. Maybe it zooms in, but that was our issue.
No, Mr. Chairman, we're good now.
We're good now? Okay. All right. I think I would know more about technology. Go ahead.
Good afternoon, Mr. Chairman, Madam Co-Chairman, members of the committee. My name is Corin Schmidt. I'm the Director of the Department of the Family Services. Today, virtually, I have joining us Dale Weber, who is the Operations Superintendent with the Wyoming Boys School, and also Chris Jones, who is the Superintendent of the Wyoming Girls School. We're going to start with Mr. Weber. Mr. Gilmore is not able to attend today, so Mr. Weber will be walking you through the handout that you all have in regard to the boys' school, and then Ms. Jones will do the same.
Thank you. Mr. Weber?
Thank you, Mr. Chairman. Can you hear me?
We can hear you.
I'm sure you've been asked that a lot over the last year and a half. Good afternoon, members of the committee. My name is Dale Weber, and as Director Schmidt said, I'm the Operations Superintendent at the Wyoming Boys School. First of all, I'd like to thank you for giving me the opportunity to come and speak to your committee. This is my first committee meeting, so I hope I follow all decorum, and I apologize if I make any mistakes. So I believe you all received a summary of the Wyoming Boys School. Obviously, I'm not going to read through all of that today. I'd just like to touch on a few of the main points, possibly expand on some of the topics, and try to give everybody a good idea of what the boys' school is and what we do. So the Wyoming Boys School was established in 1914 under the Board of Charities and Reform, and it was under that until 1989 when the Reorganization Act moved us under the Department of Family Services. As I'm sure all of you are aware, we work with adolescent males ages 12 to 21 years of age that have been adjudicated delinquent in a court of law. Simply put, they've been found guilty of crimes that are punishable by the laws of the state, or they've been in violation of a court order, i.e. probation. So a couple of things have to happen at that point once they've been adjudicated delinquent before they come to the boys' school. They have to be court ordered into the custody of DFS by a judge, and then they have to be ordered by the judge to be physically placed at the Wyoming Boys School for an indefinite period of time, which is a pretty important piece of the puzzle. So with regard to the programming at the boys' school, we have the flexibility to work with the ages of the students that come in here from the ages of 12 to 21. So each program is very individualized, and those programs are based on the age and maturity of the student that's coming to us, his history of criminal behaviors, the severity of the crimes that he committed. And we take all of those things into account before he gets here. When he gets here, he's interviewed by our intake coordinator and myself. We try to determine which dormitory he's going to be on, and then his individual program is created at that point. The average length of stay, as it shows in the summary, for the boys here at the boys' school is about 8 months, so around 240 days. The average age of the students that we get is 16 years of age, and this is over fiscal years 20 and 21. We are staffed currently at 60 beds, and that is due to the fact that we have closed one of our dormitories. So we were down to 3 dormitories, each staffed to hold 20 students per dormitory. So the programming that we have is mostly based on cognitive behavioral restructuring. I think it's pretty clear that if anybody that has an adolescent son, I have 2 myself, it's pretty easy to understand that adolescent males' biggest problems usually revolve around their inability to think about consequences, to cognitively process their place in the world. And we believe that the students that are coming into the boys' school, that's where their biggest deficit usually is they make bad choices that end up victimizing other people. And we try to do everything we can to help them reformulate their world. And when they get out of here, make better choices and have better behaviors so they can live lawfully and successfully in life. We do provide some mental health services at the boys' school, and I shouldn't say we provide. We actually work in conjunction with the local community mental health center, Cloud Peak Counseling Center. They provide us, it had been 3 full-time therapists to work with our students. Recently, we've just found out that's going to be dropped to 2 because of COVID issues with their agency. They lost a therapist. But each boy is afforded an opportunity to work individually with a therapist on mental health issues. They also are provided opportunities to do family counseling as well as group counseling at the boys' school. These services are all provided by the mental health center. They are not our staff at the boys' school. Our staff are not trained mental health workers. They also provide us an APRN that provides all of our medication services. So she works with the students on a weekly basis and provides any psychotropic medication services that they require. We also have a medical doctor that comes out once a week and takes care of any of the boys that have a medical issue that needs to be seen by a doctor. We also have a dentist that comes out on site. We have a dental office right in our school. So our dentist comes out and serves the boys on a weekly basis. And we even have a barber that comes out once a week and gives the boys haircuts. So we do have a lot of services out here for the boys, but none of those services are actual boys' school employees or state employees. They are contracted and/or we have agreements with local providers to provide those services. The other thing I guess I wanted to talk about briefly is just our education. Obviously, we are the Wyoming Boys School, so education is a premium here. We have a big, beautiful new school that was just constructed in 2015. So we have a great space for the students that come out here. We are a year-round facility. We are accredited through the Wyoming Department of Education. So all of the credits any of the students earn here transfer back to any school in Wyoming. And we work in conjunction with the different districts, the school districts, to time up our boys' releases so that they earn maximum credits while they're here. So some kids' programs may last a little bit longer or may go a little shorter, depending on where their school year fits, because we know it's such a huge piece of the puzzle to keep them in their education and get them as much education as possible. The only other thing I guess I really wanted to talk about before I leave it open to questions is I don't generally like to talk about what we aren't and what we don't do, but I think it's important to talk about the fact that the boys' school and maybe Mrs. Jones will talk about the girls' school as well. We operate in a unique space with regard to what we are. We're not a prison. We don't have fences with razor wire. We don't have guards. We don't have cells with bars. We are the highest level of secure placement in the state for adolescent males. We do have locked facilities, i.e. all of the doors are locked. The students cannot move outside of a dorm room or outside of the dorm building without a staff member unlocking for them. But we're not a prison. On the other hand, we're not a treatment facility. We don't have licensed mental health workers that are employed by us. We don't have a therapeutic milieu here. It is, although I believe we have a beautiful campus, and I think it's quite a bit, it looks a lot like a community college, if any of you have ever been here. But it is not designed for comfort and relaxation for the students here. We don't have a psychologist or psychiatrist on staff out here. So we're just not the same as a treatment facility. And we're not a detention center in that our program is designed to have the boys here longer. And there isn't a next step for them after the boys' school with regard to detention centers usually are. They're waiting to find out where they're going next. Whereas we are the end of the line in corrections for adolescent males in the state. So although we are always working on their release plan, their discharge plan, we're the highest up that they're going to go, and then hopefully they'll be able to drop back down and go back into their communities after us. So, and we're not Department of Corrections, and most other institutions that are similar to ours in other states are under the Department of Corrections. So I think that makes us unique. And I think gives us a lot of flexibility to do a lot of work with the adolescent males in the state of Wyoming. So that's all I had, Mr. Chairman. If anyone has any questions, I'd be happy to answer.
Vice Chairman Washington.
Thank you, Mr. Chairman. Mr. Gilmore, do you have any data on recidivism of young people that come through your program?
Mr. Weber.
Mr. Chairman, Representative Washut, I know that there is data on that. I do not have that today, but I would be happy to get that to the committee. Is there a time frame that you would like to see?
5 minutes. 5 minutes, says the Vice Chairman. Mr. Weber, just traditionally how that can work is if that's the only question, or there's a series of questions that maybe you don't have the info to, you can just email. You can always email that, and we all see it, whether you send it directly to LSO or to our committee, however you want. Otherwise, you can save that data for if it's a continuing topic. But since I don't know that we would be talking about it next time, whatever questions you have like that, an email's fine.
Thank you, Mr. Chairman. Representative Washut, what time frame would you like to know that data about?
Prior to our October meeting would be fine with me. Thank you.
Representative Zonitzer.
Thank you, Mr. Chairman. Can you tell me roughly how many 18 to 21-year-olds you have that wouldn't be considered juvenile, but apparently you can house young men up to age 21? Do you happen to know the number?
Mr. Chairman, Representative Zwanitzer, currently, I believe we have 3 students that are over the age of 18. I would have to verify that. We generally do not receive that many students that are over the age of 18, although some do turn 18 while they're here. Most of the time we get them before they turn 18. But if you need specific exact numbers, I'd also be happy to get that to the committee.
Thank you, Mr. Chairman. Follow up. No, just I wanted a rough idea. And then when they get placed by the court with you, do you know, are they all on Medicaid or do some come with private insurance? And if you could talk about payment a little bit, if you know on, I know the Department of Education doesn't fund you, so you're funded out of DFS and you're not corrections. And I heard everything you're not. I'm just kind of trying to figure out what in your mind you are then, and the purpose. Is it just the last stop at the line before either they go back down or they go into incarceration? Or if you could give me a little bit more on maybe what you see your purpose as.
Mr. Weber.
Thank you, Mr. Chairman, Representative Zwanitzer. With regard to the payment, a lot of the students that come in here were on Medicaid that I believe is federally matched before they come here. When they come into the boys' school, their Medicaid changes to 100% state funds from the DFS, I believe DFS Medicaid budget. With regard to the purpose of the boys' school, I'm not clear on, I guess I'm not clear of what the question is.
Representative Lawrence?
Thanks, Mr. Chairman. In your testimony, I think about 6 times you said, well, we're not this and we're not this and we're not this. But you took out kind of all of my options of what I thought the boys' school was. And so help me out, maybe in your mind, what you believe your purpose is. And I'd like to hope it's more than just being where the court sends troubled boys that they don't know what to do with. But you're not necessarily an educational facility or rehab or counseling or treatment. So help me out on what you are besides, in your mind, besides staging grounds for 8 months to just have young men hang out before something else happens to them.
Mr. Weber?
All right, thank you, Mr. Chairman, Representative Zwanitzer. Okay, yeah, I guess I didn't do a great job of wrapping up what I meant by saying the things that we aren't. I feel like we're a hybrid of a lot of different things with regard to, we are the highest level of secure placement for youth or young men in the state. So we do have some components of a correctional facility. We keep them very safe and secure. They can't hurt each other. They can't hurt people in the community. But we're also very rehabilitative and very reformatory at our school. And that's even mentioned in the statutes that we are reformatory and rehabilitative. So we're really on the ground, Representative Swanitzer, we really just, everything we do here is to try to teach these boys how to think about what they do in the world and how to change that, because we get so many angry young men or young men that just don't think through their actions and how that affects other people. We spend every waking hour trying to help these young men understand that their thought processes, if they're distorted, lead them to negative behaviors that land them in jail, in detention center, and ultimately when they're older into prison. So we're really just trying to teach them how to think and behave within the laws and rules of society.
Representative Provenza.
Thank you, Mr. Chairman, and thank you, Mr. Weber, for being here. You mentioned just that the number of therapists or people through Cloud Peak is reducing, which I would assume means that they're reducing in being able to provide mental health services. Are the number of youth that enter your facility who have some sort of mental health related issue through their adjudication process or recommendation for therapy, is that number reducing? So are you seeing fewer youth with mental health concerns?
Mr. Weber.
Thank you, Mr. Chairman, Representative Provenza. That's a great question. I've spent almost 20 years in mental health, public mental health, before I came out to the boys' school. So this one's pretty close and near and dear to my heart. They have 2 full-time therapists now that are working with our students. We've seen a reduction in how many students over the last year that we have in the boys' school in general. I believe it's heavily due to COVID-19. So even though we have 1 fewer mental health therapists, I don't believe that they're going to suffer any less or any reduction in the amount of services that they can provide. I actually was a therapist out here at the boys' school when I first came to Wyoming in 2010. So I know how many kids they can see in a week and how many groups they can run a week personally, because I did it. The therapists that we still have coming out here can more than handle the number of students that we have out here. And in answer to, are we seeing less kids with mental health issues out at the boys' school? I would say it's probably the opposite. We are maybe seeing an increase in the number of students that come to us with mental health issues and even severe mental health issues at times. So I think that's actually increasing, but I still feel very confident in our ability and Cloud Peak Counseling Center's ability to provide services for all of the students that we have.
Sure, go ahead.
Thank you, Mr. Chairman. And so with the therapists that come in, and my understanding of the boys' school, and please correct me if I'm wrong, is that dorms house youth depending on the offense that they are in for. So perhaps drug related and so forth. So are the therapists that are coming in, what are the requirements to help with, say, substance abuse treatment or the other, types of crimes that are in each dorm?
Mr. Weber?
Thank you, Mr. Chairman, Representative Provenza. The dormitories that we have are based, the placement in the dormitory is based partially on age. So generally, we're going to have the younger students in one dorm and the oldest students in another dorm. There is some intermixing of students because there's really not very much interaction between students individually anyways. But with regard to the crimes that they commit, it's their placement in a dorm is more so is about their criminal history, not necessarily their mental health needs. So with the only exception being that we generally house sex offenders on one dorm, and we have a mental health therapist that has extensive training to deal with that specific portion of mental health issues. And she's been doing that for a few years for us. So she's fairly specially trained for that population. Generally speaking, the other two dorms, the mental health therapists there are I wouldn't say basic mental health therapists, but they're classically trained in either cognitive behavioral or CBT, and they have to adjust how they work with each student based on their mental health diagnosis.
Go ahead, Representative Provenza.
Thank you. So in terms of youth that come in and being not a detention facility, but also having to have, this is the end of the road in terms of where juveniles can end up regarding detention. When a youth becomes maybe combative or there's an issue between staff and youth, what is the protocol in terms of restraints? Do we put those youth in some sort of essentially solitary confinement, and what's the procedure there?
Mr. Weber.
Thank you, Mr. Chairman, Representative Provenza. So all of our staff are trained in right response training. They're certified in that. And basically what that is it focuses on de-escalation techniques and then safe physical restraint techniques. So if a student becomes physically violent toward another student or toward a staff, or if they're self-harming, then our staff are trained to try to de-escalate them. If they're unable to do that, then they can place them in physical restraints. At times, we do have detention rooms on each dorm that are designed so that a student cannot harm other people or themselves because of the proximity in the dorm to the main desk in the dorm. We have people right there within 5 feet of that room at all times. They're on 2 cameras in that dorm, in that room. So there's just a heightened ability to monitor the student's behavior at that point. I believe that was what all you had asked about.
Representative Provenza.
Yeah. Do you know how long typically a youth might be in solitary, or the protocol for, how long we might keep them there, and when should they come out and vice versa?
Mr. Weber.
Mr. Chairman, Representative Provenza. Yes, by our policies, a student wouldn't be able to be kept in a detention room more than 72 hours. If there was believed to be a need for that, it would have to go through myself and the superintendent to be approved for an administrative hold. The 72 hours generally is the last step. What we do is it's a progressive step of safety protocols. They're generally first taken into the room, the detention room, when they've proven themselves to be dangerous to someone else or themselves, and monitored for maybe an hour. And during that time, staff is processing with the student if they're willing to process, which means they're just in there trying to talk to them and calm them down and de-escalate them. And then it continues. If the student continues to be aggressive or violent or self-harming, that would be extended to possibly the rest of the day that they would stay in the detention room. And then the staff would still continue to go into the room and try to de-escalate and process with the student. So it's never that a student does something that we don't like and he just gets thrown in solitary for however long. It's very progressive, and we're always trying to check in with the student to see where they're at, because we understand that that's the last resort. That room is to be used to keep people safe and to keep the students safe. It's never used for punishment. It's all about safety of other students and the student involved in the situation.
Last question.
Senator Provenza.
My last question. Has there been any complaints in which the boys' school has had to go through maybe DFS investigation in recent history, and what has been the outcome of that?
Mr. Weber.
Mr. Chairman, Representative Provenza, if I could, I would like to defer that to Director Schmidt.
Mr. Chairman,
Yeah, please.
Representative Provenza, if there's an allegation against the boys' school, it's treated as a child protective services case, and then we don't talk about that. That's confidential under the statute.
And on that note, Mr. Weber, I think it was about 3 years ago, maybe 4 years ago, I visited the boys' school and I had lunch there. And I recall having chicken fingers. And I just have to say, it was actually really, really good. And I don't know, I suspect that wasn't just because of my visit, but I think the food at the boys' school is doing a really good job there. So appreciate that. All right.
Thank you.
Yep. Maybe we should move to the girls' school real quick. We have Miss Jones.
Mr. Chairman and members of the committee, good afternoon. Thank you for having me. You're going to hear a lot of the same information from me that Mr. Weber shared, with probably different pronouns. But I am the superintendent of the girls' school. I've been here since 1999 in the roles of a teacher, then the principal, and now the superintendent. Like the boys' school, the girls' school was under the Board of Charities and Reform. Early inception was established in 1925. And again, like the boys' school, I'm probably going to say that quite a bit in my presentation. We moved under DFS as where we are now. Similar to the boys' school, for a girl to be committed here, she needs to be a female from the state of Wyoming, ages 12 to 21, and adjudicated delinquent. Very similar to the process that happens at the boys' school. A little bit different is, although we are one of the highest levels of intervention for adolescent females in the state, we are not a secure facility. And so what that means is all of my exterior doors on all the buildings, including dormitories and education and the common meeting areas, are on a 15-second egress. So when a girl, if she wanted to leave the building, she engages with that door. It gives us 15 seconds to interact with her and hopefully prevent her leaving the building. And I kind of have explained this to my staff, that 15 seconds is really illustrative of the crux of our program and behavior management. And that is all of the time that we spend building relationships with kids, because that 15 seconds is representative of all the hard work that's been done for months and months at a time. All of our staff are trained in MANT, which is similar to right response. And the lion's share of that training is based on relationship building and interacting appropriately with kids. And then a small portion is how to interact physically if we need to. I'm happy to say that we just don't put our hands on kids unless they're a danger to themselves or others. And it happens very, very rarely. And like I said, or like has been mentioned, statutorily, we can take kids at 12 and keep them till they're 21, but very much like the boys' school, it's pretty rare. More operationally, it's about age 13. And then around their 18th birthday, I have about 4 18-year-olds right now, but for the most part, we don't keep them past their 18th birthday. And again, like the boys' school, the residents that are committed to the girls' school are committed for an indefinite period of time, which means that they're not sentenced to 3, 6, 9 months. The court orders them to complete our program. And to complete the program at the girls' school, they need to make progress in a few areas. Like the boys' school, educationally, we are accredited, which allows us to grant and give credits. We also graduate girls if they're in the right place at the right time if they get here. We are a certified high set testing center, which is like the GED equivalency. And again, very much like the boys' school, I think if you came to the facility, and you're all welcome at any time, it looks like a private school. We don't have perimeter fencing. We don't have guards. The kids aren't in uniform. It looks like a private school. And I'm very proud that in addition to giving quality core educational services, the girls have a lot of opportunity to build skills and find out things that they might be good at that might enhance their ability to be successful at home. We have horses that they can take a horsemanship class. We have a pond, and we work with the local community organization that teaches fly fishing and how to tie flies. And a pause. I'm very fortunate that the Sheridan community really embraces us. We also partner with the local ice skating rink and have a hockey class. In the last couple of years, probably 5 years, we created a CNA class. And then this past year, we created a welding program. So they have a lot of experience, but they need to be determined that they're making progress educationally, whether that's in their 7th grade or post high school. If kids have graduated by the time they get here, we often can offer online college classes, et cetera, et cetera. Then the second part of the program that they need to be demonstrating progress in is the dorm or behavioral component. And that can be anything from some gender specific things like True Thought, which is it's a thinking error program that addresses some of the errors in thinking that get them in the place they're at. Girls Circle, cultural programming, maybe aggression replacement, those kinds of things. We have 2 operational dorms. We have 3 dorms on campus, but like the boys' school, we closed a dorm over the past year, and we have 2 operational dorms right now. And then the final piece, again, very similar to the boys' school, is the rehabilitative piece. And we partner with a local counseling center, that not the mental health center, but a counseling group, a Willow Creek Counseling, and they provide all of the mental health and substance abuse services, behavioral health services on campus. Every girl on campus is assigned a primary mental health therapist, and then depending on their treatment plan and assess needs, they participate in different group therapies, substance abuse therapy, all pretty much individualized based on their needs. Our average length of stay is about 7.5 months, but our goal from day one is to get each girl that comes here back home as quickly and safely as possible. And that's what our entire crux is of our programming is giving these kids what they need to be successful at home. Because they can be successful when they have all this structure and all this stuff, but the rubber hits the road is when they go home, and can they be successful. So we meet monthly with our treatment team, the kid, and then the home school district, probation officer, family, so that we're talking about transition from the day that the child gets here. In the last number of years, kind of on that note of giving the girls what they need to be successful, we've really focused on becoming more trauma informed and trauma responsive. And in a very simplistic way, it's that shift from not so much focusing on what happened to the girl, but I mean, not what they did, but what happened to them. And like the boys' school, we're not an RTC, residential treatment center. We don't have the ability to lock kids up, so we're not a detention. And I think Dale put it very eloquently that we operate in an interesting niche. But in that, the ultimate goal is to give kids what they need to ensure, or at least give them the skills and tools to be safe at home. You know, the girls' school motto is a chance for change. And I think that's what this is. Well, hopefully by doing what we do in the period of time that they're here, we can interrupt some behavior patterns or some actions that weren't healthy and weren't going to be productive. And we can give them some skills and tools. That's education, that's mental health services. A lot of times it's medical, dental, those kinds of things that they hadn't been getting, just even basic 3 meals a day and a safe, warm, predictable environment. And then hopefully working with the community and the families to have kids be safe at home. So I'll open it up for questions.
Committee, questions for Ms. Jones? Representative Swanson, no questions about what the girls' school is or is not? She drove it home. Okay. Representative Provenza?
Thank you, Mr. Chairman, and thank you for being here today. One of the questions that similar to the boys' school that I had was, you had mentioned that you're doing trauma-informed programming, working with girls at the girls' school. And are you seeing that there is maybe an increase of girls sent there that maybe you would feel like there are other issues that they should be dealing with that maybe the girls' school isn't an appropriate prescription for?
Mr. Chairman and Representative Provenza, we can't do everything, right? So we can do what we can do while they're here. Are there underlying issues with some kids that need different interventions? Yeah, it happens. But with the kids that are here, we really try to make their program prescriptive and individualized for their needs. Almost all of the girls at the girls' school have some sort of trauma history, whether that's physical, sexual, emotional. It's very, very rare that they don't. And so our job is to understand what role that trauma plays into their decision-making process, what role it plays in their physical and mental health, and then trying to provide them with the highest quality services to meet those needs. But similar to the boys' school, we are not a psychiatric facility. And so when we get those kids with very significant psychiatric issues, I don't have a psychiatrist on staff. We do all of that through telehealth in coordination with our local mental health center. And that's where the medication management comes, again, similar to the boys' school. Did that answer your question?
Yeah, thank you.
All right, committee, any additional questions for Ms. Jones? All right. We appreciate you being here and appreciate that report.
Certainly.
Maybe one day we'll visit the school. Do you have anything? You're just facilitating introductions for us. Okay, we appreciate that. We appreciate this report. We'll move on to our next topic. The data reporting. I'm going to dispense with the overview of the current statute. I don't know that that's necessarily necessary. I think it'll come out during the conversation. I also think we have the statute, we can read it, but also we did dive pretty deep into that in the last session in Casper. So I'm going to go straight to Ms. Chambers and Ms. Butler.
Good afternoon. My name is Kara Chambers. I'm with the Wyoming Attorney General's office. So this topic has been very robust. Actually, my initial involvement was to present data reporting for adult criminal offense. But in the course of that, we have discovered that some 20 years ago, there was a statute created to have DCI collect juvenile justice data. And you have a bill draft in front of you, which is 22 LSO 111. That is an attempt to expand upon that. the reason I am up here with my colleagues, not from my agency, but with DFS and from the State Supreme Court, is that I'd like to actually point you to tab 415 that was supplied by the State Advisory Council, because I think it's a good synopsis of kind of where we're at the moment and why I am here today to ask for more time. Juvenile justice data is complex. It's not been handled perhaps the way it should have been. There's a lot of different pieces at play. There are 2 branches of government and 3 different agencies that need to communicate, both person to person, but also through IT and court systems and data marts and interfaces and being able to analyze this data. And that has not happened to date. The reason I have Ms. Butler up here is because the Supreme Court receives data, and she can explain further on that. And the reason I've asked Ms. Schmidt to join me is because DFS obviously has a very big tie to this data, but more importantly, are currently going through or just closed an RFP at the end of August. And I was hoping that she could explain what that system may or may not be able to do. And then from there, I also have DCI here to answer questions if you have specific questions about how their operations work. But I wanted to preface this by saying what DCI does is very different than the juvenile system is set up. DCI system begins with fingerprints and works its way through to disposition. And the model for juvenile justice is somewhat flipped, where there would not be information received until there's an adjudication. And we would, of course, be receiving all of that data from other entities. So from there, I'm not entirely sure where to delve in because I really do think we need more time. I can answer questions, but I also, like I said, I'd like to hear from Director Schmidt to explain their IT solution that they're currently seeking, because I think it would be good information for the committee to have.
Co-Chairman Nethercutt.
Thank you, Mr. Co-Chair. I think maybe just to help refine the issue for the committee, not sure that's been completely refined. I think you can see the bill draft that LSO has provided, and you can see most notably the staff comment there on page 3, lines 12 through 17. And so I think we were a very brilliant committee in requesting this bill draft, but as is usually the case, those that have gone before were just as brilliant. And 20 years ago, the legislature did create a statute that asked for the court to coordinate with the Division of Criminal Investigation, the reporting of data. So obviously, we committee members could have something to work with, and we would have 20 years of juvenile data to help make us allocate resources and make policy decisions. And unfortunately, that has not occurred. And so everyone on all 3 branches of government are responsible for this failure. For 20 years, we were supposed to have been reported to about this data, and we'd never asked for the report, never received a report, obviously, and didn't review the report. So we dropped the ball as legislators. The judicial branch never turned any of the data over, and the executive branch never asked for it to be collected. So an epic failure on all of our parts, of which we all share equal responsibility for, but recognizing that issue, recognizing that there already is a law in place. How does that law need to be changed? Is DCI the correct agency to be receiving juvenile data? Are the courts in a position, in light of all the testimony we've heard about their abilities and capacities to turn over juvenile data? We still don't have e-filing or any of that technology really underway to allow for it to be utilized for these purposes, which probably would allow for very effective transmission of information. But are we just a few years out from that? And then, of course, the Department of Human Services, which houses data as well concerning juveniles in a very different way. So curious to hear kind of a summation of solutions now that we understand the problem, and we don't need to delve any more into that history, but a summation of solutions for how do we accurately capture this data moving forward?
And if I may, just to each of those three, I think what would be helpful is to each of those 3 points that Co-Chairman Endicott makes, to have an answer from, on your opinion from each of your, what, I'm going to ask for that same opinion from DCI, of course, and then from each of our branches, the questions of, is DCI the best reporting entity? Is the court in the position? And where are you at, DFS? But I think that will be helpful specifically. Thank you. And anyone can, anyone can start wherever we want to start, but we're going to go through everyone here. So maybe what is easiest is to start with DFS. Yeah, because on where you're at technologically wise, et cetera, I think is helpful.
Hey, thank you, Mr. Chairman. This is a perplexing issue because it's not for lack of interest and it's not for lack of desire to have some combination of data so that we can understand better what is going on with our juveniles and our juveniles in every system that they pop up, whether that's municipal court, circuit court, juvenile court, et cetera. We do not have the ability to communicate that across all our systems. So please don't hear me think that this isn't important, but there are some realities and some practicalities that we're faced with now. So in regard to our system that we mentioned this in our testimony in Casper last time, we are in the process of reviewing bids for the replacement of our case management system for social services. So in our social services side, we engage with families because of abuse and neglect, because a child may be in need of supervision, and because of juvenile delinquents. We have a case management system that we're federally required to have to be able to, one, know where those kids are, what their case plan is, what their status is, and two, we use it in order to pay claims to pay for services on behalf of those children and families. So it is a tremendous system that also then engages with the federal government to report a whole bunch of data points. A few years ago, the federal government updated their requirements for that system, and our current system does not comply with those new requirements. So 3-4 years ago, we started the process of having conversations with joint appropriations about procuring a new system. So that system has been procured. We're open, or that system has been bid out. We're reviewing the bids right now. The requirements and the bids will open soon. And then we will be going to joint appropriations asking for an appropriation based on that bid. This is a long-term project. It will take a couple of years, but our learnings through reviewing the proposals is that there's a lot of opportunity to use those systems to maybe enhance it to do a lot of the data collection that we're talking about here. The unfortunate issue is, one, we don't have the appropriation. Two, it's not great timing. This is not something that's going to be in place relatively soon. So if the desire to start immediately collecting data is the desire of this group, we're not going to be in a position to be able to do that. But I do think if we do get funded, that we do have opportunity to look at closer working with the courts, working with DCI and other agencies in order to collect that data. We are required to interface with the Supreme Court. So that is an interface that will occur. We are required to interface with Medicaid. That's another interface that will occur. And then I also believe we're required to interface with education. So it is a robust system that will be able to pull specific data from other systems, or at least transfer it, because we need to know those things about our children that are in our care. But it is a big project and it may or may not happen. And if it does happen, it won't happen for a few years.
Mr. Co-Chair.
Director Schmidt, is DCI or DFS better place to standardize, identify, and collect and take care of the data?
Mr. Chairman, DFS is the better agency, I think, to collect and keep that information, keeping in mind we do not have any infrastructure in place right now to do that.
So to that last point, the problem with the statute is that it mandates the wrong reporter, so to speak. So if we were to adjust the statute without necessarily having a reporting deadline, or even, I suppose the statute could take that into consideration. It could say upon the creation of or implementation of your system that you become the reporter. I mean, is there an issue with forward-looking, assuming your system goes into place?
Mr. Chairman, no, I don't foresee anything other than human resources. So with each of these systems, then also comes people. And so at some point, I imagine if that is what this body chooses to do, we'll be coming back and asking for some sort of appropriation for a person to help with it. We don't have the current staff. So even though we may have the system, it still requires people.
Right. And the reason I asked the question that way is because I haven't done this forever, but I've done this legislating process long enough to figure out that if everything's hinging on appropriation, for one, to a system that we don't have, but statutorily, we have the wrong reporter and we know that right now. But if we do nothing and take into consideration, whatever you meant, Ms. Chambers, by I need more time, then I know in a couple of years, this committee, if not a year from now, this committee could very well look completely different and start from ground zero all over again, getting back to this exact moment in time where there's that aha moment. We all agree, as well as Co-Chairman Nethercott put it very bluntly, that there's just a failure on all branches of government with this, and we have a real issue. So I don't want to be in that place where we brought the ball this far and now we have, but I don't want to mandate what we can't do. So that's why I asked the question that way, so that the ball can continue moving forward. And if the statute's broken, we should be fixing it. We shouldn't have the wrong entity as the reporter, period. And I suspect DCI will have the same answer. Co-Chairman Nethercott, did you have a question?
Thank you, Mr. Co-Chair. Dr. Schmidt, thank you. I heard you said the idea, if the software is able to come through all of the different entities that need to talk to each other and where that information would go. And one of them was identified as the Supreme Court. Is that correct? Why the Supreme Court?
Mr. Chairman, Senator Nethercott, I do not know what the interface will be, and that's something that I can find out. I believe it has to do with the filings of the juvenile court proceedings, but
Ms. Schmidt, wouldn't that be the district courts? Because that's the district court's data, because all of the juvenile cases occur in the district court. And this is just a communication I'm sending out there. We smoothed over a bill this morning called a unified court system. This is one of those issues where this touches on in so many different ways. So should DFS be interfacing with the district courts as opposed to the district courts communicating to the Supreme Court, back to you regarding maybe some of this juvenile data? So just something to think about as we move forward about whether or not the Supreme Court should be the entity responsible for that juvenile data.
I feel like Butler really wants to weigh in.
Mr. Chair, Madam Co-Chair, again, Elisa Butler, I'm the State Court Administrator for the Wyoming Supreme Court. And I believe the reason that interface would need to be built with the Supreme Court is because we provide the Judiciary, or the Supreme Court provides the case management system for all of the courts throughout the state. We have built over the last probably 10 years, a data warehouse where some of that data lives in our system. And so that interface would need to be from our system, our data warehouse, into DFS's system, whatever that looks like. So there would need to be basically a bridge built between our data and theirs. One of the things that you heard me talk about at the meeting in Casper was the fact that we have never reported on juvenile data out of the data warehouse. It lives in our data warehouse, but we've never created reports out of it. And so Because of that, one of the things that we have not done in the past is combed through that data to ensure its accuracy and to ensure that what we would provide if we were reporting out of it would be accurate data that could be relied upon. One of the things that we are working on now with the new case management system that we're rolling out is, number one, providing a more uniform system. Our current case management system in most of our courts was configured court by court. So comparing apples to apples was incredibly difficult. The other piece of that is we're providing training, a whole lot of training to our district court clerks moving forward on how to enter data and the statistical model that we're using moving forward. And so those are the two pieces that we are working on to ensure that that data is better in the future. The other thing that we have talked with the district court clerks about, and they are ready to dive in if possible, is to try to clean up some of that old data. So that will take time. It will take resources. And I know you hear that again and again, but it is a heavy lift. It's a heavy lift for us at the Supreme Court to create those reports. It's a heavy lift for the district court clerks themselves to go back and clean up that data. So those are some of the pieces that we are working on. And if this body decides, that however that looks, that uniform reporting system across all agencies, if that requires an interface with the Supreme Court data warehouse, that's something that we would definitely be open to working with DFS or DCI on to ensure that it happens.
Representatives Wanitzer and then Vice Chairman Washut.
Thanks, Mr. Chairman. And first, real quick, Representative Craig reminded me I'd led the charge to take out the $250,000 appropriation for curtains and tinting in the windows. And so we saved $250,000, but I apologize for the light source. Seemed good at the time. My ultimate question, though, is as I listened, that we already had an RFP is currently out right now. I'm a little worried. Does the RFP clearly state that the information currently in statute is being asked for and the interface will happen? Or are we now already behind the gun and we have an RFP out there that may not even be asking for what we need?
Mr. Chairman, Representatives Wanitzer, the RFP has been closed. We are now reviewing proposals. So no, it does not include the data that would be requested here beyond what we already collect through juvenile court in our system. However, the information that we're gathering through those proposals indicate that the possibility would be there. It probably would require an additional appropriation because it is not included in the current scope of work, but that is a potential.
Vice Chairman Washut.
Thank you, Mr. Chairman. Mr. Schmidt, my question along the same line is you've already gone out to bid, so I'm assuming you already have an appropriation for that records management system. I want to clarify that. And what beyond that would you anticipate would be, and I am not asking for a detailed list, but generally speaking, what additional requirements would DFS experience if this responsibility were shifted to your agency?
Mr. Chairman, Representative Washut, the way that this project has transpired through the last few years has been a little bit different than the usual IT project. So last year, the JAC and the governor asked us to go out for bid without the appropriation and to come back with the bid and then ask for it in the 23-24 budget. So we are preparing that information to go before governor and then the joint appropriations. In regard to your question about what would we need, certainly people. I think my bigger question would be is the people who would be entering data on the community side, on the county side, et cetera, without knowing exactly what the court systems already collect. There are some questions that I would have about what is it that the counties would need to enter and what would be the agencies responsible, our responsibility in working with those counties in order to get the data entered. So if that would require training, if that would require some sort of coordination, so that would be another factor that I think would need to be considered.
Just a quick follow-up for any of the three of you from the data collection that we have experienced right now. My understanding is pretty fragmented, that not everybody is uniformly submitting information. What suggestions would you have for the proposed statute to ensure that we get more uniform reporting from those agencies that have data that we need, that don't always report that data to a central clearinghouse?
Ms. Butler.
Mr. Chair, Representative Washit, I can tell you from the perspective of the courts, I don't know that we would need anything additional. It's something we're working on right now. It's not, I will tell you, data has very clearly become a priority. And I would say, I don't know that we had fully recognized how important it was when we first implemented Y-User. There were pieces of data that we knew were very important, but we're beginning to recognize how all of it plays together. So that has become a priority for us in the administrative office at the Wyoming Supreme Court, and something that we're working through with the circuit court clerks and with the district court clerks, as I said, with the new statistical model, and then just creating those training opportunities for the clerks to ensure that the data is entered uniformly. So statutorily, at least from our perspective, I'm not sure that there's much else that I would suggest to make those requirements. The kind of data that we do collect is case-centered. And so if you're looking for data about diversion programs and how effective they are, that's not necessarily data that we would have or that our clerks would know or be able to enter. So some of those data points are things that that may be a question, but that's not necessarily something that we could report to you all.
Ms. Butler, so statutorily changing what is reported, is that what you're talking about? That you don't really see a need for any change to the statute? But you're not talking about the reporter piece of the statute. Who is reporting? Who is housing?
Mr. Chair, that's correct. As far as who would be the entity that provides that data to, DFS, DCI, we can provide the data as long as we make sure that it's accurate. And we have that case data. And so in looking through some of the specifics of the bill as it stands currently, there's some of this information that we have now, and I would be I couldn't say with 100% confidence that it's entirely clean, but there's some data in there that we could probably provide today without a ton of work. Some of those things, very, very simple things such as the juvenile offender's name. We generally don't get social security numbers, at least not that I'm aware. The juvenile offender's date of birth, not the place. We don't generally get that information. A physical description, I think in some circumstances we get that, but not always. And I don't know that it's always entered into our case management system. The juvenile offender's last known address, we could probably provide that. The juvenile offender's fingerprints, that's an interesting one. So if you look at Wyoming statute 146240, it actually limits when fingerprints are supposed to be collected from juveniles in juvenile delinquency cases. We don't get those fingerprints at the court, so that's not something that we could report out of. The criminal offense for which the juvenile was adjudicated delinquent, again, that would probably take a bit of cleanup, but I think there is some data in the case management system and potentially in the data warehouse for that. Identification of the juvenile court in which the juvenile was adjudicated delinquent, we do have that information. We know which court it was in. And then the rest of those provisions, those are the pieces that I think would take some cleanup work on our end to ensure that it's accurate when we report out of it. And that includes things like the disposition ordered. And then when you're looking at, some of those other provisions, I'd have to go and talk with our database administrator to have a look through our data warehouse to see if any of that is actually collected currently. I would guess, we get the disposition, but anything that happens after the disposition, I don't think that's currently entered into our system. So those are some of the pieces based on the bill that I think we have. It would take, again, some work on our end to create those reports and to ensure, working with our clerk's offices, that they are actually accurate reports.
And so the information that Ms. Butler, you have in your warehouse, so to speak, of data is coming from the clerks and only from the clerks?
Mr. Chair, that's correct.
Okay, and Director Schmidt, this list in 503A1 list that we just walked through, your office would have your DFS would have almost all of this data. Maybe not a fingerprint.
Mr. Chairman, we would not have those that were not filed in juvenile court. So if the case were filed in a municipal court or a circuit court, we would not have that information. That's the information that would have to come from their court system. What we would have is, without having looked at this really quickly, we would have quite a bit of this data in our YCAP system, our current case management system. And just for a little bit of context, we weren't really quite prepared to have this conversation today to be able to delve into what DFS could do and could not do. And I think that is the request that Ms. Chambers was asking, is to give us a little bit of time. The idea of switching data collection to DFS actually came up, I think, on Friday. And so we haven't had time internally to process a lot of this information. So I do think it would be worthwhile to go through each of the data elements, understand what we collect right now in our current system, understand what we would be able to get from the court system, and then make some determinations about what would our new system collect as well before we settled in on any laundry list of data elements.
Mm-hmm. So one possibility, Director Schmidt, then is, rather than having no bill, if we could simply just move this bill forward to the next meeting with DFS as a reporter, and then have that full conversation after you've had more time to look into more than just Friday, right? I mean, that's not going to do any harm because if we have that conversation then at the next meeting, and we'll know a lot more about whether we should continue moving forward with that or not, but there won't be any harm in moving that bill forward, making the DCI change at least right now. Would you agree with that?
Mr. Chairman, yes, I would agree if we had a little bit of time before your November meeting, is it, or is it October?
It really should be November, but I think it's October. I think it's late October. Oh, we always have a Halloween meeting. That's why. Yeah, so it's these two meetings are actually, barely a month and a half apart, actually. Senator Cooper, please.
Thank you, Mr. Chairman. Ms. Chambers, maybe this is for you. Other than time and money, what do you need from us is the first part of the question. And secondly, we got a lot of really good conversation here on how we're going to collect this data. What are we going to do with it? Where does it go? What's the end result? Thank you.
Chairman, Senator Cooper. The testimony you just heard from these wonderful ladies on either side is that they have the data. We would merely be the receptacle, as it were, and would have to, per the existing statute, sort of come up with some sort of reporting mechanism and then report it to whomever was authorized to request it. The reason, and it is very short notice, because I think it was sort of just one of these things where, wow, we've had the statute for 20 years and nothing has ever happened. We've never received the data. And quite frankly, the Juvenile Justice Act is not within our agency's real wheelhouse. There's so many different considerations with juvenile data that DCI isn't really set up to properly address. I think one reason, and we'll admit this, that 20 years ago, well, none of us were here. So can't really tell you what happened then. But, you know, we should have developed rules to figure out how to deal with this. I've heard from the Supreme Court that that might have been some of the chilling effect in them transferring the data, but the bridge has never been built. And since we're where we are now, we're suggesting we don't need to be part of this bridge because part of the data comes from DFS, part of it comes from the courts. And all you're asking us to do is set up a system that doesn't exist. And so, yes, it does come to time and money. And we're just saying there's probably a better source of it. We would obviously fully support DFS with any request for appropriations because this is a big lift. And that's probably why it hasn't been done in 20 years. I would like to note, Senator Endicott, that Director pointed out to me that we have provided reports, but they simply have the number 0 in them. For the record.
And for the record,
Co-chairman?
I think Representative Wanser, you were almost here 20 years ago, right?
Oh.
14, 15, how many years in the?
18.
18.
There've been some
So-
people in the room who've been here more than 20 years. Go ahead.
Co-chairman, so is that data inaccurate? Do we need to go back and amend those reports to unattainable as opposed to 0? Perhaps.
Chairman Olson, Co-Chairman Endicott, perhaps, but that was all we were able to report on.
Vice Chairman Washer.
Thank you, Mr. Chairman. Just a comment. As we move forward, I fully appreciate your being asked to set up a system that doesn't exist. But I think within that system, as it's built, accountability has to be factored in. It's simply unacceptable to have individual players in this complex system who opt not to play. And we have to have a mechanism that holds individual data holders accountable for not sharing that data under this new bridge system that we're creating. And so I just urge you to include accountability in your anticipation and planning. Thank you.
Chairman Olson, if I may briefly respond, I just wanted to clarify that I thank you, Representative Washut, for your comments. And tomorrow we can discuss DCI's role in that for the adult system because we are in agreement on that. So I just wanted to preface that we will have a more robust discussion about accountability in criminal justice history information.
Senator Kolb and then Senator Cooper.
Thank you, Mr. Chairman. Well, I just like to say to everybody in disclosure, I'm only a tiny bit responsible for this mess because I haven't been here very long, but I've certainly heard enough and I've seen issues before in government. So I guess I think there needs to be some teeth in this. You want to know the truth because you guys, frankly, you outlive my term in office and then you retire, which I think is what happened as I recall recently. So, we need data and we need to make sure there's accountability and we need to have a system that has consequences for non-conforming of the statute. I think that's obviously what needs to be done because we all might not be here. And then what? We talk about this again another 20 years from now, and I'm sure other folks might be here, but try to get something to move forward and get us somewhere where we need to get data because the whole thing hinges on data. And we don't, obviously, zeros aren't helpful. So I'd like to work together and I'd like to hear what you have to say about how to get there. Maybe together we can figure out what to do to go forward. Thank you, Mr. Chairman.
Any response? A mandatory report? I mean, to Senator Cooper's earlier question, what are you going to do with the data? And the fact that Senator Endicott also pointed out that our branch didn't really follow up on this for 2 decades. So is a mandatory report to the Judiciary Committee the solution of?
Chairman Olson, Senator Kolb, what I'm here to suggest today is that DCI be removed from this juvenile justice component.
Okay.
We are very much responsible for the adult system and we can have that conversation. There is a statute that requires reporting. And I'm just talking the adult system. And we have talked about whether or not that has teeth. I have data that I can present to you, that I plan to present to you tomorrow on all of the law enforcement agencies and their status of reporting into the National Incident-Based Reporting System, NIBRS, which is the adult system. But you're right. But what I'm suggesting today is to say that no matter where this responsibility for juvenile justice gets placed, we're starting from scratch. And I can't change history. We can accept responsibility for it, but we are where we are. And moving forward, I just think we need to look at it where it makes sense and who has the data. And so it sounds like the courts get a large portion of the data. It sounds like DFS has another portion of the data, and it's going to take resources to develop a system for juvenile justice reporting. I'm merely suggesting that DCI is not the appropriate place for that.
But Ms. Chambers, to his question, do you have an idea of what is, we understand we can change the reporter on this, and it sounds like we probably will, but what is the teeth mechanism? Because I really think Senator Kolb's point is very accurate, not just about the legislators that will be here in 20 years, but the three of you are sitting at the table telling us that it's a very important topic to you. And I absolutely believe you when you say that to us. But what do we do for future generations on this? Yeah, the statute exists and the warehouse exists with the data and the report can be produced, but if everyone's not talking to everyone, and more importantly, simply put, if everyone's not putting the data in, all the data, then what does it really do? So do you have thoughts on that?
Chairman Olson, as far as juvenile justice data, we don't know who is or isn't reporting because we've never received the data. We have a system that is separate from the adult system that was developed as a receptacle, but again, there were concerns. There were some very valid concerns from the Supreme Court on transferring the data. So I can't answer the question on, I can answer that for the adult system of who is and isn't reporting and what we can do about that. And again, that's maybe for tomorrow. But I can't answer the question as far as who is or isn't reporting. And I don't know if Director Schmidt has any thoughts on that as far as the Juvenile Justice Act reporting.
Mr. Chairman, so if I understand the question correctly in the general context is how do we require that reporting happens and that this effort isn't lost 20 years from now? And I don't really have a great answer for you in terms of the accountability. I do think mandating some sort of report that at least gives you some high level aggregate data so that you know that the data is actually being collected is one. The important component of this conversation that we really have not hit on is why are we collecting the data and who's going to analyze it? Because there's going to be questions and we can't ever assume what those questions might be. We know right now what those questions could be, but future writing that into statute, my experience is that oftentimes when we write things into statute, they become irrelevant and we're reporting on things that no longer matter. So I would urge you to think about, there may be some general requirements to put into statute for reporting, but it's the analysis that's even more important. And then I think the expectation would be, and I apologize to my future self in this or my future, any future directors, but understanding what the agency did with that information and how policy decisions were made as a basis of the data that was collected. I also think that if you would like to see some accountability on the legislative part, is a willingness to entertain policy changes based on that data that may include an appropriation. And I think one of the examples that I could give for that are diversion. And I know that's a big topic of conversation. I know Machine has some strong feelings about that. But the reality is that we're in a place right now where our budget is really limited. And yes, there's some argument about moving money from one place to the other, but that's over time, that's not instantaneous. So if we're going to require the data collection, I say we require some level of reporting, we require some level of analysis, but we also be open to some ideas of legislative policy and budgetary changes as a result.
Senator Cooper.
Mr. Chairman, Schmidt, I think that pretty well answered my questions. We don't really know what this data is actually going to be used for. it's mandatory reporting. My position sitting up here, and I'm asking you ladies if you agree, is we're in a position to listen to you. Please bring us whatever needs you have and let us help you with it. That's the best I can offer. I don't think any of us really know what this data is going to be used for. We don't know if we're asking the right questions or the wrong questions. But bring us your needs and let us help you. Thank you.
Mr. Co-Chair.
Yeah, please.
Yeah, just a reminder, this was our #1 topic for the Joint Judiciary Committee, which was juvenile justice. And I think it became the #1 topic out of allegations that Wyoming has one of the highest juvenile incarceration rates in the country. True, untrue? I don't know. We don't have the data, right? So that's a reason. That's how the data could be used. And there is no lack of interest in juveniles in the state. There are organizations in every county, multiple organizations, layers and layers of groups and nonprofits and government entities that are focused on helping youth, right? So I would be hopeful that they also could use the data to understand where resources can best be placed. So when the state is struggling with finding resources and allocating them appropriately, that's how the data can be used, right? So is it true that we're incarcerating juveniles at a greater rate? And is that good or bad? Are they receiving the services that they need in the Wyoming Boys School and the Wyoming Girls School, resulting in reduced recidivism rates and long-term success? So you can make an inference that we have high incarceration rates, which may or may not be. And incarceration isn't even the right term either, right? High placement rates, right? So I mean, whatever we'd like to call it, is it achieving the results we want to receive? Are there different programmings we can use? Should we be spending our money differently and more effectively and more efficiently? And I think it's fair to say that none of us know the answer to that question, but we are committed to finding it. And so that's the goal of the data.
Representative Zolan,
Thanks, Mr. Chairman. I'm just saying I have a great motion after public comment on where to get moving here.
I appreciate that. Can't really respond to Co-Chairman Nethercutt's. That's a great place to leave it, I think. Okay. All right. Thank you very much. Real quick, DCI, come on up. We did not have you at our first meeting, so we didn't have an opportunity to talk. Obviously, I think the committee is, and the stakeholders, everyone's at a general place of your agency being, for lack of, I guess, a better terminology, wrongfully placed as inside of the statute. So just want to get your opinion on that. And then generally, if anything that you've been listening to that you'd like to discuss, we'd love to hear from you.
Mr. Chairman, Madam Chairman, members of this committee. My name is Forrest Williams. I'm the interim director for DCI. With me is Allison Moore. She's the deputy director over our CJIS unit, which is our criminal justice information sharing system. We're happy to answer any questions you guys have. In relation to the discussion that's been taking place, I agree with Director Chambers. I don't believe DCI is the best suited place to house juvenile justice information. There's a number of reasons why. From a resource standpoint, we certainly understand resources are limited. And if you want to try to best leverage your current resources, it would make sense from my perspective that the agency such as DFS or the district courts, the Supreme Court that already has the data, that's where it stays. I absolutely believe we need the data. I can only point the finger at one agency for the past 20 years, and that's my agency. I haven't been the director for 20 years, thank God, knock on wood. You know, as Madam Chairman said, you need data. Absolutely, that data is there. It's just a matter of figuring out how to extrapolate it, how to gather it, how to store it. So if you're leveraging resources, why build a bridge between another agency such as DCI to simply send that data to us? To me, that might not be the greatest expenditure of resources.
Vice Chairman Washut.
Thank you, Mr. Chairman. Director, can you think of any information that might be held by law enforcement when a case doesn't develop that might be pertinent juvenile information, where the case doesn't get forwarded to the juvenile court, doesn't end up in a DFS case? I'm just thinking that maybe state and local law enforcement might be the repository of at least some pertinent data. Can you think of some examples where that might be the case?
Director Williams.
Mr. Chairman, Representative Washut, I'd have to think on that some more, but yes, I think there is. Certainly from, and maybe I'm going down a rabbit trail here I shouldn't go down, or a rabbit hole, but certainly from the perspective of like investigative type information, is that what you're referring to?
Potentially. I'm thinking of cases where maybe an arrest is made, but there's no prosecution, or it doesn't go any further, or there's an investigative look, but not necessarily any further information from there that goes into these other systems. I was wondering, I don't want to cut DCI and law enforcement completely out of this data gathering if there might be some pertinent data that best comes from you all.
Director Williams.
Mr. Chairman, Representative Washut, so when you're talking specific to juvenile justice data, that information is still being reported through local law enforcement through NIBRS, our National Incident-Based Reporting System, which is replacing, I think, as a lot of you know, the whole NCIC reporting. So we still would collect some of that data.
Follow up. I guess it's essential that we, when we build this new system, this new bridge, that if that data is being collected by school resource officers, for example, in a school district, if it's coming in to DCI through NIBRS, I want to make sure that the bridge connects to that data source. So if DFS is going to be the repository, I want to make sure the bridge extends in all the necessary directions.
Fully understand that, sir.
Senator Cole.
Thank you, Mr. Co-Chair. On the NIBRS, do we have full compliance with the reporting with all counties, that data?
Director Williams.
Mr. Chairman, Senator Cole, the short answer is no, we do not yet. We have put together a report where out of 59 law enforcement agencies, 38 of those agencies are reporting data in NIBRS, leaving 21 of them that are not. And there's a multitude of reasons why they're not. I could further explain that if you would like, sir.
Brief follow-up. I understand there's some that don't report. My point is, how can we make them report? What do we need to do to get compliance? Any suggestions, sir?
So this issue is something we have talked about at length internally within our agency and within the Attorney General's office. You know, many of the services that we provide to local law enforcement and to other state agencies is certainly something I would be hesitant about suggesting we reduce our participation or our assistance in order to make a local law enforcement agency mandatory report. And simply the reason why is it's your constituents, it's the citizens of Wyoming that would suffer if we did that. I've heard that there's been discussion of if a local law enforcement agency is not going to report in neighbors or do mandatory reporting, that possibly they pay a penalty, so to speak, when they send people to the law enforcement academy. Is that a good idea or a bad idea? I honestly don't know. I do believe there has to be accountability. I think we're witnessing right now why 20 years later, we still have the same problem we've had for 20 years. It certainly is a lack of accountability. So yes, there has to be accountability. How do you enforce that? Somebody a lot smarter than me would need to come up with that, but I would love to sit and discuss various suggestions and ideas. I don't know what the best way is.
Senator Cole, you good? Yeah, go ahead, Representative Oakley.
Thank you, Mr. Chair. Thank you, Director. Just a quick follow-up on Senator Kolb's. I thought I heard you say that you had some ideas, maybe why the 21 weren't reporting. I'm assuming maybe rural or small districts. I don't know, but if you have any ideas or thoughts on that, would you share that?
Director Williams.
Mr. Chairman, Representative Oakley, the biggest reason that we have heard that agencies are not reporting, the most common reason out of the 21 agencies that are not, is it's problems with their vendor. And that is the software company that runs their record management system. And the most frequent vendor problem happens to be with a company called Spillman. Okay. We ourselves use a different vendor. I can tell you it was a nightmare getting our vendor to make sure our record management system was capable of reporting through NIBRS. A lot of it is, it's a new program. I think some vendors believe that possibly the federal government could step in and help with some of the resource issues. I don't know. We have heard the most consistent problem is the vendor not getting things operating correctly. And then it's a huge staffing draw. Several agencies believe it could require possibly up to 1 or 2 additional people just to report all the required data into NIBRS. And I can tell you in our agency, and we don't take near as many reports as most of your local law enforcement agencies, especially agencies that are mid-size and larger. But I can tell you, we have multiple people in our agency working part-time, wearing different hats to try to make sure we're NIBRS compliant. So it is very labor intensive.
Mr. Co-Chair?
Please, go ahead.
Were you intending to provide that list of the 21 tomorrow? Yeah, great. I just think it'd be helpful for us to know that specific detail so we can interface with our local communities that may be experiencing those challenges, help them come up with some solutions in order to deal with those issues.
Madam Co-Chair, if I may,
Yeah.
through you, Chairman,
Ms. Chambers.
I don't want to conflate the two issues because has nothing to do with juvenile justice. So I just wanted to be very, I mean, we're not getting any of the data, so it has nothing to do with reporting into NIBRS, which is a very different system, incident-based, not necessarily arrest-based, but I just wanted to make sure that we're clear that we separate those two issues, which we are prepared to talk about more at length with relation to bias crime reporting and the bill drafts that you have there.
I feel like I had a question on the side. Was it just Ember? Was it you, Representative Provenza? Go ahead.
Yeah, and I think I can save this question for tomorrow because it's about NIBRS reporting. Thank you.
Lots of questions teed up for tomorrow. We're gonna hold till tomorrow. All right. Representative Lawrence, or does?
I still have a motion on a bill when public comment's done. Mr. Chairman, no rush.
Thank you, Representative Lawrence.
Trying to- Yep.
Appreciate that. Thank you, DCI. Okay. All right, public comment, please. In the virtual world, do we have anyone specifically lined up?
You know, Mr. Chairman, we had Mr. Odakoven sign up for public comment, and he's on here. We can go ahead and admit it now if you wish.
Okay. I thought there was somebody missing in this meeting. I figured out who it was. Raise your hand if you're going to provide public comment on this topic in the room. Please. Nobody. That's a half hand. That's a full hand. Okay. I'm just trying to get an idea because, yeah, why don't you come on up to the table so you're ready to go and I can turn over to you right after Byron. The ship's going to go really fast over the next 20 to 40 minutes. Byron?
Thank you, Mr. Chairman. Byron Odakoven, the Executive Director of the Wyoming Sheriffs and Chiefs. I think listening to the comments, I appreciate the direction I sense the committee may be going and determining where we need to be with juvenile data and how best to collect and disseminate. And I think in the interest of time, I think I'll wait with further comments for the NIBRS discussion tomorrow, where I think we're more maybe able to correlate a little between the two and have a better discussion of some data requirements. But I also want to echo earlier comment on the juvenile that it is a time and money and personnel issue to be able to settle on and understand some of those juvenile data sets from a very fragmented system of everybody trying to keep the data that they need for their particular report, but not necessarily the data that goes in someone else's report. So having a centralized system to be able to do that would be good, Mr. Chairman.
Great. Thank you, Byron. I always appreciate it. We're sad that you're not here in person to join us as you usually are.
And thank you.
Maybe next time.
Yes, sir.
All right. Ladies?
Can you hear me okay? Okay. Mr. Chairman, Madam Chairman, members of the committee, my name is Dr. Caleb Bird. I'm a professor of psychology at the University of Wyoming. My training is in psychology and human development. Today, the views I express are my own. I just wanted to speak for a few minutes to touch on points such as those made by Co-Chairman Nethercott about how much impact we could have if we had this data and what sorts of questions we could help to answer should we have standardized data collection across the state. I'm here in support today of juvenile justice reform more broadly. I've been working really closely with the Wyoming Children's Law Center, Ms. Sheen, other colleagues and at the university and elsewhere to try to help aid in these efforts. With my background in social and behavioral science, I have focused most of my time analyzing the data that we do have that's been accessible to us to try to help gather a greater understanding of the system and an analysis of, again, the data we do have available to us. And I think some of our preliminary findings can help answer the sorts of questions that we're really after and that we could really glean should we have standardized data from across the state. And so I think these findings help draw connections between what it would mean to have a fuller picture of the data in the state. So for one, although we encountered incomplete data, which made it difficult to fully examine the system, some of our analyses revealed some troubling trends across the state. For one, our analyses revealed disparate treatment for justice-involved youth across the state, and this included racial disparities in delinquent placements, as well as delinquent placement numbers that vary quite substantially across the state. So regarding access to incomplete data, we were unable to accurately report the number of youths assigned to delinquent placements for several racial groups. So for instance, those whose racial or ethnic background was unknown, also Asian Americans and Hawaiians and Pacific Islanders. However, even with this incomplete data, there were notable trends. We found that delinquent placements for white youth are actually on the decline across the last few years. However, we noticed that the relative number of Black African American youth receiving delinquent placements has remained steady across time. We have to determine the cause of these racial disparities in the treatment of these youths.
With the data that we have now, we can't fully understand the mechanism by which these disparate treatments are happening, but moving towards a standardized decision-making process that might reduce discretion, increase objectivity, these sorts of things would help lead to perhaps a reduction in these racial disparities. So next, we wanted to conduct some analyses that controlled for the population of these various groups across the state. And here again, we found large racial disparities across the state. We found that Black youth were over 4 times as likely to receive a delinquent placement compared to their white counterparts. Now, again, without a fuller picture of the data, we can't know by what mechanism this is happening, but we do know that with more standardized data and greater collection from across the state, we could try to piece together what's happening. And also this points to the broad discretion in the state. And so perhaps by creating more objective placement criteria for these children, we could help to reduce these discrepancies. And again, to Director Schmidt's point, Co-Chairwoman, and other points, there are many important ways that we can use these data. So we just wanted to highlight what we are finding so far and make it known that there are a lot of us out there that wish to help. And so there's a big question about once we have the data, what sorts of folks would be willing to help step up in these efforts? And I think I speak for a lot of my colleagues when I say there are many people invested in these children, and we're happy to help in any way that we can. Thank you for your time.
Thank you, Doctor. Questions, committee? No? Okay. Got off pretty easy. We appreciate your testimony. Is it, I'm sorry, have you provided that material to us by chance? Is it in our?
I have, but unfortunately just recently on Friday, but I have copies here if you'd like other copies as well.
We have an electronic version of it? Okay, perfect. Thank you.
Thank you again.
Ms. Sheen? Oh,
Mr. Chairman.
I do have a gavel, but go ahead.
Members of the Joint Judiciary Committee, again, I'm Donna Sheen. I'm the Director of the Wyoming Children's Law Center. Probably want to, I know I'm the one who maybe stirs up some of these problems in the past, and I wanted to give you a little bit of a reflection of why that is and what my background is. I began on this journey of juvenile justice reform by working for the Department of Family Services. And in fact, that was my first job out of law school. And I led a committee that was organized by Joint Judiciary. I coordinated it in order to revise our juvenile justice statutes back in 2001. We unfortunately only got the child welfare reforms done. And then, you know, as you know, and as you talked about, issues change. What we're focusing on changes. So over the past 20 years, though, I've also worked for the Department of Corrections as an administrator. And then I started the Wyoming Children's Law Center, mainly because I felt like there needed to be an outside voice that that helped keep pushing the issues that were important to children. I'm here today for a lot of reasons, and I know the committee is short on time. I know the committee has received a great big packet of information about recommendations that I want to that we've made. So I want to at least give you some context to that. But before I do that, I would like to maybe just speak about the data issue, because it does sound like it would be helpful for me to give you some history of what's happened over the past 20 years. We have been talking actually about data problems for over 50 years, and I could bring you reports and evaluations of our systems from that far back where this has been an issue. Part of what, but we have made progress in it too. I just want to also say that. We need all of the agencies that were up here to be collecting data. It certainly isn't one agency or another. Law enforcement agencies report generally to DCI through criminal justice systems. We need to be able to say that they are be able to direct them to collect the information we need about the juveniles when they're citing a juvenile, when they're, arrests or citations. That system, it would be helpful if the committee clarified what they want DCI to be collecting in that realm. I certainly agree, though, that the juvenile justice system is probably better housed under Department of Family Services. And that is because back in 2015, this committee and the legislature did pass a bill that did create a system that we haven't talked about today. I'm not sure why, except that I think the funding for it has gone away, but it was called ROM. I do think we talked about it at the prior meeting. What that system is doing or was doing until the legislature defunded the Community Juvenile Service Board was collecting data from prosecutors, which is a very important piece of information that hadn't been collected before. And they were doing it in a very simple manner, and I believe it can continue. It was a spreadsheet right now that was being submitted by county attorneys with some key information that had been developed, key data points that the State Advisory Group and DFS had developed together. And unfortunately, that data was only coming in from the 15 or so counties that participated in community juvenile service boards. And it was sort of a carrot and stick, or a carrot with no stick, that if we were giving money out to them, they had to report this data as part of receiving the money. Of course, now they're not receiving any money from us. So we're very worried that that reporting, that one key piece of information that at least provides us a little bit of a picture of what happens, is going to be going away. So that is why in the recommendations that I made under the data bill, I encourage you to, and I think it can be a simple bill, to simply direct the Wyoming Department of Family Services in collaboration with the State Advisory Council on Juvenile Justice to continue collecting that, at least that minimal data, and require it from all counties. So all county attorneys or county attorney offices would need to report that data about what they do with juveniles. That data helped give us a picture of what county attorneys do with their discretion. Because some of you may know, we've given under the statute, county attorneys have the discretion to decide whether a juvenile will be prosecuted, whether they'll be diverted to some non-criminal process, whether they will be charged in a municipal court, in a circuit court, which are both adult courts, which have no juvenile protections, or whether they may be prosecuted in juvenile court. So that piece of data, I believe, is the most critical to try and maintain and continue. So I would encourage you to think about that. And then in addition, we have been trying for a number of years also to get the court data, but I certainly agree it is there. It should be available. And I believe what would be helpful in that realm would be to just simply mandate that there be certain reports generated on a regular basis and identify ways that, for example, researchers like Professor Bird, who just testified, would be able to access that data to do some analysis when needed. I would also want to make sure I've covered that. I do think on all of the data, it is important to put provisions in on who can access it or how we can access it. We've, in the past, we've tried to get some information through Freedom of Information Act requests. The data that Dr. Bird analyzed was from a FOIA request we made to the Department of Family Services. And so I do think it's important for that data to be available also to communities, to nonprofits who are trying to write grants, for example, to develop a program. We need that kind of data to be able to support those requests. And so as money shrinks for state services, we really need to be supporting nonprofits and being able to get that. And then Mr. Chairman, I guess I do have comments about other, about the boys' school and girls' school testimony and other topics that I thought we may be talking about, but I want to be cognizant of your plans. And so if you would prefer I wait for a different public comment period to continue those, I would be happy to.
Thank you, Machine. That, I guess that would, I don't want to tell you that I don't want your comments, but that would be my preference in general, is that based on Representative Zwanenster's desire to amend this bill, I think there's going to be a lot more discussion, at our next meeting. And, the boys and girls school was intended to be a simple report to our committee. But certainly as it relates to juveniles, that will be on our next agenda. And I do have 2 additional items that I want to cover this evening. So if there's something that you would like to summarize quickly for us, so we can take that. If you have something more in depth, maybe save it for the next meeting and or send us an email, that would be helpful.
Well, thank you, Mr. Chairman, for that clarification. And I will try and do a quick summary of some of the things I think are important for the committee to consider. I provided you with, I know, a very extensive letter with 7 bills that I was recommending. Those bills didn't just come out of thin air because I was, sitting around thinking what I could do. They were very thoughtfully crafted after talking with a lot of different professionals. We've reached out and kept the Prosecutors Association informed of our work, and a number of other people. We've been working with both the Defender Aid Clinic at the UW Law School and also the Prosecution Clinic. And both of those directors have indicated that they are happy to come at the next meeting and also address the importance of some of those issues and their support for why these things should be done. I know that you've heard that DFS has submitted for an evaluation, and at our last meeting, we talked about how important an overall evaluation of our system would be. And my hope is that that happens. But regardless of that, whether it does or doesn't, the 7 items that we recommended are things that I believe are fairly non-controversial. They're needed, and I think that they would put very important guardrails in place that would not only help prevent unintended harm for juveniles by putting them in a system that isn't addressing their needs, but also save the state money during this very difficult time. I think especially the limitations or the need to have criteria for making recommendations to a court for an out-of-home placement is really critical. I would point out that the competency statute and the ages setting a floor for juvenile court involvement also will limit and shrink our system. We're all facing, the budget cuts and the difficulty. You heard the testimony of needing more judges. We also need to think about shrinking our system in order to be able to live within our means. And so I think limiting the age of jurisdiction for when children can even be brought to court makes sense. And it's also consistent with the science we know about competency, which most of these young children, 12 and under, are not even legally competent. And if we challenge their competency in court, there's a good chance they wouldn't be able to proceed then, but we would have wasted a lot of resources arguing about that. So I would encourage you to think about that, also establishing the prohibition against use of juvenile detention for municipal courts. The reason that's important is because kids end up in detention in municipal court, I think, by accident, quite frankly, or by the system not really having a mechanism for turning kids back. A prosecutor may decide that an offense should be charged in municipal court, but then because it's going to be a fine or something, and then the youth doesn't pay the fine or doesn't do the community service, and the court really in a municipal court is left with only one alternative, and that would be to confine them And so I think that, again, is a waste of money. It's very expensive to confine juveniles. And it also defeats the purpose of the Juvenile Justice Act, which is we want to respond appropriately. And removing a child from their home at that age can be very traumatizing and unnecessary as well. So I would encourage you to look at that bill. The diversion, requiring a diversion program for all counties. The reason for that is that we found that there is huge disparities in terms of what kids can face in the different counties. And when a county doesn't develop a broad array of options, that includes diversion, they're more likely to get to the higher end of their spectrum more quickly. In other words, they're likely the communities that may be overusing more expensive placements like the boys' school and other types of confinement of youth in residential treatment facilities. So I would encourage you to also consider sponsoring that as well as a committee. Thank you, Your Honor. Thank you, Mr. Chairman. Did it again.
If we were in the Commonwealths, I might be tempted because as part of their dress, I would be wearing not only a robe, but a wig.
Yes.
Ms. Sheen, we went ahead and recirculated your email to all the members, so that should be fresh in front of you with the 7 concepts presented by Ms. Sheen and the bill proposals that will be in front of you, should you be interested in making a motion. All right. Thank you, Ms. Sheen.
Thank you, Mr. Chairman, members of the committee.
All right. Sorry. Representative Provenza, go ahead.
Thank you, Mr. Chairman and Ms. Sheen. Quick question. You mentioned that you had received data from DFS and state entities and without county, and we know that Volunteers of America is kind of hosting some of those facilities and work. So were you able to obtain data from them? Did you ask for it? How does that kind of like nonprofit sector work in terms of transparency of data?
Mr. Chairman, Representative Provenza, thank you for that question. I did forget to mention that key piece of data that I think the committee needs to work on. I did request the data from Volunteers of America. I have not been able to obtain it from them. I think it's a gray area in terms of whether we can do FOIA requests with them, but it's certainly an area that the committee should consider when it's wrestling with this data problem. For those of you that may not know this, Volunteers of America receives a grant from the federal government Office of Juvenile Justice and Delinquency Prevention. Because we are a non-participating state. In other words, we don't take the federal money on that. And we stopped taking the federal money. I could probably tell you, I won't go into that right now, but if any of the committee would like to understand that, I will just say that we have, I think, 2 options right now. We can hope that someone else will apply for that grant and try and collect the data. And the data I'm talking about this is detention data that must be collected. And it is detention data for all levels of court for any kind of detention. So for example, the boys' school classified or said that they don't consider themselves a detention center, but under the federal definition, they are a detention center. And so the Volunteers of America program did 2 things. It provided grants to communities to help fund things like diversion programs and juvenile justice interventions that could help a county. And it also was required to collect the detention data from all of the counties. And so that data, in theory, has been reported to the federal government, but I have yet to access it, and I'm not certain how to access it.
This time, thank you, Ms. Sheen. All right, with that, I will close public comment. And committee, what is your pleasure? Representative
Thanks, Mr. Chairman. I would, let's move the bill to the next, my motion would be to move LSO 22-111 juvenile justice data reporting to our November meeting. And if I get a second, I'm going to bring an amendment.
Your motion is to move the bill, move it as a bill.
Move the bill as, for further work at our November
For
meeting.
further work at our next meeting. Okay,
And then with a second on that, Mr. Chairman, I'd like to make the following amendments. Kolb second, right? So then, Mr. Chairman, it'd be on line 11, instead of Title 7, we're probably going to go somewhere in Title 14, the DFS statutes at Mr. Fuller's discretion. And I just want to run through the bill real quick. Similar bill, put it in DFS statutes in Title 14. And in regard to those staff comments, the one on page 5, yes, I'm going to go quick. I do think the boys' school, the girls' school, and the Wyoming State Hospital should be included in detention for our reporting. So that'd be my first amendment. I guess that'd be the second after Title 14. And then on page 9, for that staff note, no, I don't think just the allegations need to be included in the statutes. They better be, if they're alleged, I don't think we need those reported unless they're already adjudicated or charged. And then I'd make the effective date, Mr. Chairman, let's say 2024, which would give time for the RFP to come in, appropriations to hopefully give the money. If they refuse to, and this bill goes forward, we could put the money in. That'd be a fun fight on the floor. And then when it goes into effect in 2024, that would give time for the systems to be up and running. And I'm sure we'll have more amendments on it as it moves forward, but those would be my 3 immediate, if I could get a second.
is there a second to that substitute bill? Yes, seconded by Representative Oakley. Thank you. Mr. Fuller.
Yeah, Mr. Chairman, I just want to be clear, except for the changes that Representative Zwanzer discussed. The first change, I just want to make sure I'm clear on, it would just basically be moving the article as it exists in total to Title 14.
He says yes.
I mean, that takes it out of DCI's purview statutorily and puts it somewhere in DFS's purview statutorily, and with further direction of changing division to department, adjust as necessary.
Okay, yep,
Okay,
sounds good. Thank you.
all right. Discussion on the amendment. Ready to vote on the amendment? All those in favor of the amendment signify by saying aye. All those opposed? Okay, that amendment's adopted. The bill. Discussion on the bill. Question on the bill? Roll call on the bill? No, I'm sorry. You didn't want. I'm just trying to move this along. Okay, no official roll call on the bill.
And I'm just trying to keep this very slow, Mr. Chairman. I'm.
Okay,
I just had a question, and forgive me for not knowing, are the counties included in this as mandated for reporting? If anybody know?
Representative Zwanzer.
So there would be an ongoing question on municipal actions, which I didn't want to try to solve tonight. County, I would believe the district judges of any, I guess I'm not sure what the question is, for violations that went before the judicial branch would be covered. So any infraction of a non-municipal law, I assume, would move forward.
Representative Oakley.
Thank you, Mr. Chair, and I'm not sure exactly where it's at, but so if it's a diversion program, then you're either going to go to county attorneys or district court. And then if it is charged as a criminal charge, not gone through diversion, then you're going to be at a municipal or circuit, or again, your county attorney. Is where that information is. Now, how we've got it written, I guess I'm not sure.
Maybe the question is, how do you want it written? Do you have does somebody have a preference? We can, I'm just suggesting that because if you do have a preference, we can make sure that's at least moved forward into our draft for discussion in the next.
Mr. Co-Chair, Representative Provenza, what is it you're trying to capture?
Thank you, Madam Co-Chair. I guess hearing in testimony that having detention facilities in say a county that is not the detention center of the state, is that included in this? And I think because it's deemed a detention center, but I'm just clarifying that it is not just the state detention centers. Does that question make sense?
I think that that is being captured for how the juvenile got placed in that local facility.
All right, thank you. That's all I.
So all those in favor of the bill draft? We voted on the amendment. That is a substitute bill. We're done. That's moving forward to the next meeting. Okay. The next topic on the agenda, there are summary of research requests. I'm going to dispense with that by saying, look at your materials committee. And I'm not going to make Mr. Fuller summarize that for us, but if you had any specific questions based on the materials that the summaries that you received, I would certainly allow you to ask those questions now to Mr. Fuller. Representatives want to.
I just wanted to do a quick shout out and thank you to Ms. Creech and Mr. Shiznais for the excellent job. This was one of my requests at the last meeting, and they both went through and got me exactly what I wanted to know. So just wanted to do a public acknowledgement and thank you.
Thank you for that. And please don't interpret me not having the summaries read in as not appreciating the work that you put in. We do look at them and we do use them. It's just time is sensitive. Maybe. All right. Next topic, State Advisory Council on Juvenile Justice. We're not going to summarize the statutes. And that Ms. Nunes or Dr. Nunes, doctor, is it professor? Professor Nunes. Okay. We'll, yep. Go ahead.
Thank you, Chair. So today what I'd like to do is just apprise you of some of the things that the State Advisory Council has been doing since our June meeting when Co-Chair Nethercott kind of lit the fire under us. So what we have been doing, I just want to let you know what we've been doing. Oh, before I do, can I just say one thing about the data collection? You know, I work with counties. That's the level that I work at. And the counties need their own data. What tends to happen is they put the data into some system, it goes to DFS, it goes someplace. And then when a county wants their own data so they can report to their county commissioners about what's been going on with juveniles, and they can't get their data. So whatever system, in terms of access, the counties need to be able to get their own data back because ultimately they will be responsible for putting the data in. And they feel left out of this because they can never get their own information back unless they create their own data system. So I would just sort of say, please remember them when you're thinking about this.
Professor, that might solve the problem because then we could ask the counties to pay for
Well,
system.
We had a system in place, right, with the community juvenile service boards. If this was something that you wanted to put throughout the state to create some mechanism for this, have these boards that are funded, every county could put their own data in because we have single point of entry in the state. Also, I just want to mention that the Wyoming Survey and Analysis Center, which just to throw another fly in your ointment, is also working with counties and they're collecting all the diversion data. So you asked the question about diversion. There are a lot of counties working with the Wyoming Survey and Analysis Center, putting their data in because they're trying to evaluate whether diversion is working or not. So you might want to consider the Wyoming Survey and Analysis Center as another entity yet again that might be able to help you, okay? So let me just tell you what we've been up to. First of all, one of the first things we did, we had a council meeting right after the June meeting, and we voted to look into, we have OJJDP money from 2020 that we didn't use because we didn't meet. And so we are talking to OJJDP as to whether or not we could use that money to fund a juvenile study, which I believe you were talking about last time. So we're looking into it, and it was Chair Nethercott's idea. So we are looking into it, okay? The other thing we did is we partnered with the Department of Family Services, and we submitted an OJJDP grant for $2 million for the state of Wyoming. We will find out in October. Yeah, in October, whether we would get this money. This money, the grant that we wrote was to fund a juvenile justice study that I believe you talked about last time. Also, we put, I believe, about $150,000 into the proposal for data collection so we could help fund a system. And we also included a study of diversion. So we've been very active trying to drum up money, which is dearly needed. We also, the State Advisory Council also applied for ARP funding. And I believe it's in your packet. We requested Recovery Act money to fund the juvenile services boards for 3 years. Now, I know the governor has a lot of requests and they're working through some of these requests, but funding our community juvenile service boards is not really going to take a lot of money. So maybe it might rise to the top. So we are trying to get the money back to the community juvenile services boards. And in fact, in this proposal, I believe we asked for money to fund every county. So again, making this a statewide thing instead of just a 14 county thing. So fingers crossed. I don't know how much money we asked for here. I believe it was a couple $1 million. So we've been busy. Also in your packet, we have our data committee put together a list of recommendations for when you consider data and statute and legislation, some of the things that you might want to think about. And one of the things that hasn't been said a lot, but just a little bit, is the county level stakeholders. You've got to get buy-in from the county level stakeholders because they're the ones that ultimately you're going to need to rely on them to get the data. And they're really they've been fired up for the past year. So many counties I work with, Hot Springs, Uinta, you name it. We've been working with all these counties and they're fired up to do this. But if we could just keep thinking about them in terms of the data collection. And I believe, and along with all this good news, I have a little bit of bad news. So yes, we've been beating the bushes for money, but we haven't got a yay or a nay on any of this yet. But we just found out that we are losing $500,000 next year. Donna mentioned, Ms. Sheen mentioned that the Volunteers of America is doing our non-participating grant. They did not get the grant this year and they're not going to be applying anymore. So we have to find a nonprofit organization to apply for that money. Because what happens is, because we don't participate, a nonprofit organization has to apply for the grant, get the grant, and then fund different communities and their programs. So next year we'll lose a little bit more than $500,000. Again, it's another hit to the counties because this is directly to the counties. So it's not statewide, it's county level. So the counties not only lost their CJSB money, but they're now going to lose their non-participating money. So you may hear from some of them. Questions?
Senator Kolb.
Thank you, Mr. Vice Chairman. Why did they lose the money? Could you expound on that?
So I'm not really clear because they just lost the money. There were some questions about, they had a deadline in which they had to apply for the money. They had some problems and I'm not exactly sure what they are. You'd have to ask the Volunteers of America, but they missed that deadline. And because they missed that deadline, OJJDP said, you can't have next year's money.
Thank you, Mr. Chairman. Ms. Nunez, you mentioned earlier that YSAC was working with counties to collect diversion data. Can you tell me who's funding that?
Yeah, Chair and Representative. Yes, the Bureau of they have a $150,000 grant from the Bureau of Justice Statistics to develop data systems to help inform states about different kinds of justice issues. And the last 2 years, they applied for money to help with juvenile justice issues. So they have developed a data collection system they call Reroute. And it's pretty fancy, it's pretty nice. And there are a lot of communities, they're currently working with communities on developing the MOUs so that they can start using the data system. So it is free to the counties.
Thank you, Mr. Chairman. Just one follow-up question. How many counties are participating with YSAC?
It's unclear at this moment. I know there are a lot of counties that want to. They're waiting to get their MOUs signed, but I'm guessing that it's mostly the communities who have the community juvenile service boards to start with, because they're more connected to everything that's going on in the state. So that I have talked with Converse County, which is not a CJSB community, and they're interested in joining as well. So we may pull in a few more, but everybody is invited. YSAC is saying anybody who would like to use this data collection system can.
Co-chairman Nethercott.
Thank you, Mr. Co-Chair. Who would be the grant recipient for the $2 million you've applied for?
The grant recipient will be DFS. DFS is the person or the entity that applied for it, and it had to be the state. Is that correct?
And so, as you know, my concerns are it may be appropriate to repeal the advisory council statute as a result of its kind of challenges associated with fulfilling its mission. What do you propose to do with that $2 million if it is granted to DFS? Will DFS give that money to you to then give to the counties, or how will that money be allocated? I heard there was $150,000 kind of side noted as a request for data collection. So where will the rest of that 1.85 million go?
So the way it's divided, and first of all, I missed one entity, and I'm very sorry. The governor's office is also a part of this project. So I apologize for not mentioning that. So the money would go to DFS, and DFS is hoping that the State Advisory Council would sort of issue RFPs. One of the things that was mentioned last time, I believe, from the Council of State Governments is to do an in-depth study of the juvenile justice system, and the money from this grant would be there to fund that study if the group wants to fund the study. One of the things that I believe was mentioned last time, a couple of people mentioned, how much is this going to cost? And so we thought, well, we'll write a grant, and if we have the money, then maybe we could fund the study. So we would put out an RFP for the study and also an RFP for the data collection. So no entity has been named.
Mr. Co-Chair, follow up. So I understand that the grant hasn't been awarded yet, and it's probably very unclear if it will be, but Director Schmidt, I see you may be providing some information. Will there be funds to pay for a study, for example, by CSG to do the work that the state should have been doing for the last 20 years out of that grant funding? And where will all that $2 million go or be allocated?
Mr. Chairman, Chairwoman Nethercott, first of all, I think it's $1 million over the course of the 3 years. So it's not a large sum of money. Dr. Nunez is correct that a portion of that would be allocated to do an evaluation of data, where strengths, where weaknesses. It would look at then the review of all the current legislation and then the different activities, I guess, or initiatives that are being conducted, like, for example, YSAC. A small portion to the system that YSAC has, I think the 150,000.
I don't think we've allocated it to anybody. We're at cross purposes here because we wrote this so fast. We didn't name a data collection entity because, again, we wanted you all to guide us and tell us what you wanted to do. I sent the request for proposals to your group, to the Joint Judiciary, and I understand that you don't have grant writers. So when Director Schmidt said, why don't we team up, then we went ahead and but it really would be directed by you folks. What entity do you want to do the data collection? Who do you want to do the study? That kind of
Mr. Co-Chair, follow up? Well, that's an interesting perspective because, and I'm curious that you've pushed that back to the Joint Judiciary Committee, which we certainly would love to provide input about that, but it is the council's statutory obligation to come up with this, provide this information and to provide policy guidance to both the executive branch and the legislative branch. So, you know, how would you choose to follow your statutory obligations, I guess, so you could report back to us to provide us the right data and information so we can make appropriate policy and resource decisions?
So in our, in our proposal, we proposed to set up a task force that would include council members, members from the legislature, DFS, community stakeholders, to kind of manage the grant and make sure that it was going the way it was supposed to. And based on the information, so for example, if we RFP'd and we had 2 entities that applied to do the juvenile justice study, we would be more than willing to review those grants and make a recommendation.
Is that a governor's task force then? Is that how that would be set up? Or is it just an informal?
Mr. Chairman.
Yep.
If I may. So this is how this played out, and it was very quick. The deadline for submitting the grant, I think after we found out about it, was like 2 weeks or so. So it was very rushed. The overall idea was based on the conversation we had in Casper last time, where there was the conversation with CSG about doing some sort of analysis of our juvenile justice system. However, it was also apparent from that particular hearing that data was a big deal. So we thought that what we could do is submit a request for proposal, and then in that, get an analysis of the juvenile justice system and including data, what data is available, what data is not, provide recommendations back to this group or back to the original group. And then that somewhat does what CSG did be on behalf of DOC, but this was just with federal grant money. We've received word from the feds last week that they're in flux with their grant decision-making. So there's a potential that we may not know if we're awarded until December. We were hoping originally for October. Now it's been put off to at least December. We may know before that. The idea was for the SACJJ to basically manage. So we would be, DFS would be the fiscal agent of that grant. And then the SACJJ would make the administrative decisions, of which we are a member of the SACJJ. The reason for that is because they have broad representation throughout the state in different types of levels, not only levels of government, but different interests. So we felt like they would be a better entity because it was so quick to gather the necessary stakeholder information in order to really put together a strong effort. So that's the basics of it. The proposed budget we can send to you if you'd like to see that. At this point, it's just broad allocations. We did not dig into a lot of detail, but understanding that we knew as part of that grant, we would need to have some data collection capacity.
So no statutorily dissolving the SACJJ until they expend the grant that they may receive. Well, okay, until the grant is expended. All right. Committee? I guess to answer your question, though, I would like to see the outline of what that looks like. Senator Cole.
Thank you, Mr. Co-Chair. Just briefly, it seems, I know you're very passionate about this. It seems to be your life, concern a lot about it, but I think that looking at the whole situation, totality, it seems like the lack of data, seems to me have driven the formation of this advisory council, people trying to get arms around this, right? Well, I think until we get data, I don't know if there's a purpose for the advisory council. And I just wondered, what your justification is for continuing on if you have no purpose, because we don't know what the data is yet. We seem to be stuck in a quandary of people trying to repair a problem for 20 years. I guess, can you help me out with that? Thank you,
Yeah,
Mr. Chairman.
I think I can. Data is very important to us, and it has been a limiting factor. But one of the things that we have managed to do without any kind of state sort of support in terms of monetary, we worked with counties. So we do 4 different training sessions each year for counties. We've had teaching them how to write grants, how to manage their data with whatever spreadsheets they have. So we have probably much more close relationships with counties than we've had sort of statewide. So we have been doing that. We have been doing outreach so that our outreach committee and our services committee has put together all of the different kinds of juvenile services and nonprofits in the state. The counties come and ask us for information. So I feel like we have been more successful from the bottom rather than the top. Also, we go to different communities at each of our meetings. So one of the things that we do is that we tour the facilities in those counties, and we hear from the people who are providing services in those counties. So we start to establish a relationship. So Thursday and Friday, we'll be in Basin for the first time and talking to them. So I guess we're sort of the arm from the governor's office. We have a liaison from the governor's office that sort of guides us, and we let the governor know what's happening at the county level. But data would be wonderful too.
All right. That's all we have. Thank you. Committee? Anything on this topic?
Mr. Co-Chair, just a comment to round out the day. I think what we've learned is that there are a number of statutes with requirements that no one follows for decades. And that is a culmination of our day. And I say that with some humor, and I also say that with sincerity. And so, you know, the people of Wyoming, all of us in this room, all of us across the state care about juveniles and juvenile justice and want to do right with appropriate resources. In defense of the council, they've never received an appropriation, and it is a volunteer board in all essence. And so there's just minor reimbursements for costs associated with meetings. And so we appreciate all the members of the council who have really given and volunteered significant time and effort on behalf of the children of Wyoming. And so I want to make sure that's clear. Unfortunately, I'm not sure it's, at least from a legislative perspective, you know, it's resulting in the type of outcomes we would hope or need in order to continue to make these policy decisions. So that's where I'm going to leave it. Not getting information from any of the agencies who we've required to report to us. All powerful legislators over here. So, you know, we just need to be mindful of that as we move forward and be diligent in making sure that despite our efforts to protect and do what's right by the state's children are actually, you know, achieving the outcomes we're hoping for, other than just anecdotally, we think maybe that's the case.
Co-Chairman Nethercutt, I think it's a amazing point, but, and I will also say this, I think that one of the downsides to our part-time citizen legislature in our revolving door of representation is just that, you know, one of the primary functions of our branch is oversight. So oversight of everything we put into those green books. And, you know, a lot's been said about it, but I think that at least on some of the topics we've been talking about, and I just want to say this so that members might take it to heart, because we all get drawn out on reports, and we get tired of reports, and we get tired of requiring reports, and the executive branch and the judicial branch gets tired of providing reports because it's a resource heavy concept, but that, I mean, other than that, how do you provide oversight? Because you create so much, which we do, and then how do we keep track of what it is and bring those agencies back in front of us so that we can continue to supervise what we have created in those green books. So just some food for thought as we're pressing forward, and our seats will soon be filled with other representatives. But I think that reporting mechanism is very key to oversight. Representatives want to answer?
Are we on to the next topic, Mr. Chairman?
Me.
Sorry, I was waiting for the helicopter to pass for those people watching at home. I'm gonna wait just a second. And so, Mr. Chairman, just as a matter of process for especially new members of the committee, this is really the last meeting where we can move draft bills forward to our next meeting for them to be committee-sponsored bills for the 2022 session. Juvenile justice is our #1 issue. And although we've done some good work, I know the Wyoming Children's Law Center did introduce 7 pieces of legislation they would like us to work on that are concrete. Full disclosure, I don't actually agree with some of them. But as I was looking at what this committee could do and what we probably should discuss at a more macro level, 2 of them do stick out to me. And so if I could have your indulgence for about 5 minutes to talk about at least the 2 that I think this committee could work on. First would be #3. This is on page 137 of your e-notebook. It's the one that says Wyoming Children's Law Center at the top. But #3 is the structured decision process for out-of-home placements. Really talking about that Wyoming, from the data we do believe we have, just has a high level of juvenile confinement and what we call, congregant care, that's more expensive. And I do think, not that I don't trust our judges, but they may even appreciate some more structure on how to make those decisions of what to do with juveniles in need of services and what the best place would be. And my hope is that we can find some things that work better for juveniles and reduce our costs by looking at the draft they provided. And I think that would be worthy of discussion at our next meeting. So I would go ahead and move as a draft for our next meeting, the issue on the structured decision process tree for out-of-home placements to be discussed.
All right, that is moved and seconded by Representative Provenza. Discussion on the draft. Committee, I'll just say, I think, I mean, you have another meeting. I think Representative Zwanzer's point is a very big one. This is our #1 topic that we as a joint committee decided to look into, and we produced 1 solid bill and 1 bill that we halfway agreed to produce. So we don't have a lot of production. At least I don't have a strong opinion right now, not at 5:37 PM on that, but I would just urge the committee to at least get it into a draft and have something to talk about. Whether you have some of these bills that you'd like to move forward the same, but I'd sure like to have something substantive to talk about beyond 1.5 bills. Those are my thoughts. All right. All those in favor of the bill draft signify by saying aye. All those opposed? No. Seems like that motion carries. Do you have another motion?
I do, Mr. Chairman. On that same list would be #5, and this is on the minimum age for what's considered juvenile delinquency. They put forth an argument for 14. I'm not sure I agree with that, but I do think it is probably a legislative prerogative and worthy of a committee discussion on what the legislature's position is to convey to the judicial branch as well as the executive branch on what, if there even should be a minimum age, or if it should be, per case by case. I do think that's worthy of discussion when we have our judicial branch send juveniles to the boys' school or the girls' school. If there should be a minimum age and what the pros and cons of that could be. So that would be the other one I would like to personally take up that I think would be worthy of this committee's time.
Is there a second? Oh. Seconded by Representative Provenza. Mr. Fuller, just quickly question I haven't had a lot of time to look at these, but are we talking about something highly significant in time for you to put together? You've already got, well, not
Yeah.
his drafted bill,
Yeah,
but
Mr. Chairman, I have taken quick looks. We can draft these. And Mr. Chairman, just want to, we do have one more person for public comment
oh,
at some point today,
okay,
who's online.
thank you. Senator Kolb.
Thank you, Mr. Co-Chairman. I just kind of see that we've got limited time. We got Title 25 to do tomorrow. It's a big deal. I know it's, we ran up against a wall here with the juvenile justice issue with reporting, and we don't have data. But I think we have to, be cognizant of staff's time, and I think there's a lot of big things to bite off tomorrow when it comes to Title 25, which is a very big deal to me, at least. I'd just like to put that out as a reason why I'm not supportive. Thank you, Mr. Co-Chair.
We still have a couple hours of daylight yet. Okay, any other discussion? All those in favor of bill draft on topic 5? Establishment of age for delinquency jurisdiction, signify by saying aye. All those opposed? No. No, it's okay. It's okay. My hearing's not bad. All right, sorry, Representative Zornser.
I would say, Mr. Co-Chairman, if I can,
Yeah.
to bring up the idea, because there's a lack of data. There are bipartisan organizations out there who come in and do that, just did it for us on or on criminal justice reform, reinvestment, which is CSG. We want the data and want to make, somebody turn off their mic, decisions about that soon. That is one way to do it. They could come in and probably get data within a couple of years, because they'll go into all of the counties and look at all of the court's information and put together their best practices and consolidate that information. So I do know it's expensive, but it is the state's prerogative to have that information to make policies for juvenile justice. So it's up to the committee. I know it ran that by the committee at the last meeting. There seemed to be negative interest in that potential option. So I don't know where the committee's at now in light of the fact that we have no information and likely will not for a significant period of time.
Okay.
Mr. Chairman, I
A
would
couple-
say all of the things in number 5 are actually contained in the motion we already passed for number 3.
Mm.
So we only need that one going forward.
Okay. So that all turned out just fine. All right, I would have moved number 6, but that's just me, probably. Okay, anything else? Representative Provenza?
I'll motion to move number 6.
Ah. Elimination of delinquency fees.
Mhm.
Is there a second? Seconded by Representative Yen. Turns out I wasn't alone. Discussion. This Senate, you didn't see this bill, but House we did. This is the Representative Stivar, I believe, bill that we saw on the House side. I don't recall exactly what happened to it. Too many bills. Representative Provenza?
Yeah, just quick comment on moving this and removing the fees. We've seen that there's certainly enough adult data to suggest that when we invoke fees, that it costs us more money to get those. I would also argue that youth who are not adults do not have the ability to be anything but indigent. If they're going to school, they cannot necessarily have a full-time job that would allow them to meet the standard of what we would consider not indigent. And this puts an undue burden and also doesn't work in terms of getting youth to not reoffend. Oftentimes because those fees are paid for by their parents and may be struggling to pay those fees.
Further comment? Question? All those in favor
Mr. Chairman, they did not, but it was an email that I believe was forwarded this morning from Christina Gilbert.
Okay, well, we have one more topic yet, CHINs. We were provided a summary overview, Mr. Fuller, and then we have Judge Wilkin lined up. The summary overview is of our existing statute.
Yeah, Mr. Chairman, that's correct. And what that memo also includes is information regarding what other states have done in terms of this idea. And the concept that was raised at the last meeting was this, potentially considering a shift to children in need of services versus children in need of supervision. The memo, Mr. Chairman, committee members, includes a sampling of what other states do. Some states simply use the term children in need of services and have a nearly identical scheme to what Wyoming does in terms of supervision. There's other states that have both children in need of supervision and children in need of services. The distinctions seem focused more on things like, habitual truancy or running away, but has a narrower set of options that are available. One state, and this would be Florida, has the concept of families in need of services and provides a statute and rulemaking authority for that, the analog department to the Department of Family Services to work with families who have children who are in need of services. Mr. Chairman, I'm happy to answer more specific questions if the committee has them.
Questions, committee? Yeah, Representative Zwanitzer.
Thank you, Mr. Chairman. I guess my question, I don't care what it's called unless there's opportunities for greater amounts of grants, federal dollars, things that would help our system without costing us more. Any idea if we change the name to services that it allows us any further funds or any greater benefit to solving our issues?
Mr. Fuller.
Mr. Chairman, Representative Zwanzer, I do not know that if a change in nomenclature or even if a change in services would open up opportunities for grants.
Director Schmidt.
Mr. Chairman, Representative Zwanitzer, probably not. At the way that CHINs are organized right now within our funding system is that if they are financially qualifying and if the service qualifies for 4E reimbursement, then we'll get 4E reimbursement on those youth anyway. So that would be, I think, the only potential funding source that would be available for this type of court action.
All right, committee, any other questions for Mr. Fuller? Or now that you have Director Schmidt? Yeah, Vice Chairman Washington.
Thank you, Mr. Chairman. Director, the idea here was that if we changed the title and perhaps expanded the list of options that the district court or juvenile court might have available, what might be some of those additional services that you would recommend be available to a juvenile? Because I think the testimony last time was that some children are being classified as CHINs simply to access services. And that maybe there might be a better approach. So what services would you think might be expanded here?
Mr. Chairman, Representative Washit, when a child comes in on a CHINs petition, the full array of services that we provide are available to those youth. I think there's a philosophical difference between why a child comes in under a CHINs versus a family under, in some states called FINS, family in need of supervision or services. And I think the difference is that why is the family involved? Under a CHINS, there's some behavior by the child that comes to the attention of the system. And in order to provide services to that child, then the family has to engage with the court system. The court then decides, is in fact this child in need of supervision? And then that whole family comes under the jurisdiction of the court, but it's because of the child's behavior. And so it may be that philosophically, is it fair to that child that that is the way that they enter into the system, when in fact it could be a family issue? There could be maybe some neglect that's occurring, but because of the conditions of the family, it's easier to file a CHINS rather than abuse and neglect, especially with older children. What we find with CHINS petitions is it's really about children with severe mental health issues. That is a lot of what we see in terms of our CHINS. They haven't committed a crime, so they're not a delinquent, but there's obviously a lot of services that the child needs. Once they come into the system under a CHINS petition, then we have money to be able to place that child in some sort of placement, like a residential treatment center or a group home. If they've committed a crime while they are on their, as a CHINS, then they could also go to the boys' school or the girls' school, but that's a few steps later. There was a time in, I think, the mid-2000s or so, where our CHINS rate was really high. We had a lot of children coming into care because there were no other mental health services available for children in the community. As a result, Medicaid started the Children's Mental Health Waiver. And what that allowed is that a child who has severe mental health issues could access services that are provided for by Medicaid without having to come into the custody of the state. And as a result, we did see our CHINS petitions go down, and then that system is through Medicaid, and we do have families that engage with that system. Sometimes when that's not enough, then a CHINS petition gets filed and then we get involved. And then again, there's jurisdiction by the court.
Quick follow-up. Do substance abuse issues fall under that mental health category?
Mr. Chairman, Representative Washit, yes. Children with, I don't remember exactly what the statute says, but it's almost incorrigible behaviors, right? And then the child is just somewhat uncontrollable by the family. But again, philosophically, that's the child who's coming into question, not necessarily the family. Although we do have times where it's probably the underlying family issues that are part of the problem.
Thank you, Mr. Vice Chairman. It sounds like it's working. I mean, it sounds like you found a way to provide a level of service that is economically less impactful to the state through different methods, depending on the case. So do you feel it's necessary that we, I don't know, have a separate category or restate an acronym? And would that make things better for you or the folks you serve? Mr. Chairman, ma'am.
Mr. Chairman, Senator Kolb, I don't have the data to support this, but what experience tells me is that what we do is we blame the child for the behavior when sometimes maybe it's underlying family issues. By expanding the definition to include families, then there's a way for the courts to help the whole family and not necessarily at the cost of the child being labeled. However, I don't know how often we encounter that, but a change in definition would certainly, I think, philosophically allow us to think about the family who needs support, not just the child.
Follow up. Would that have a negative impact financially for the state by handling it in a different way, or it's just a way of labeling things differently?
Mr. Chairman, Senator Kolb, there could be a potential impact. Our caseload could go up, which means then that we're spending more money on those families. So yes, there could be, but I have no idea what that would be.
You have me on your list because Mr. Fuller called me and asked if I would speak to you at your request, just based on perhaps some testimony I provided when we were in Casper. So I may have said too much when we were in Casper. I'm unclear what prompted the invitation, but I'm happy to visit with you about the chins.
District judges to testify, and now I understand why.
Yeah, you get invitations to come back.
Did you have a specific question, Representative Washit?
Thank you, Mr. Chairman. Your Honor, when we look at these difficult cases of kids that have family problems and mental health or substance abuse or whatever, I took from the conversation in Casper that the court had an idea that perhaps we could deal with these cases without tying up court time to deal with Shin's petitions. We've heard testimony from the director today that there's a narrow opportunity with psychological services and substance abuse issues. Is that sufficient as a diversion to get these cases not filed in juvenile court, or is more needed?
Chairman Olson, Representative Washit, I asked around after I got the call from Mr. Fuller, from my colleagues, and had also looked at some data that the Department of Family Services provided to you and the materials for the Casper meeting. And I think you can recall in some of those charts, they had it broken down by jurisdiction, the number of CHINS filings for those counties and the dollar figures that went along with those. And I was struck by the disparities there. You know, I think Natrona County had less than 5 for some, and then you had other counties that had much higher rates of filing for CHINS cases. Keeping in mind, these are prosecutorial decisions that are being made about how to bring the case to the court. We have no control over that. But I did ask around, and I checked with my local DFS district manager to figure out why the numbers were so different. Interestingly, Albany County doesn't do any CHINS cases. You won't find a CHINS case filed in Albany County. And some counties have much fewer filings. In Natrona County, we have a pre-CHINS like action team that has Mercer House, somebody from the school district, somebody from DFS. And, you know, through single point of entry, these kids come on their radar screen, and before they ever make their way to a district court filing, these folks are knocking on the doors. They're getting those services front loaded before anybody ever thinks about contacting the county attorney to bring a petition. Some of my colleagues said, well, that's great for you, Casper, but I don't have anything like that in my community. And so that's what my county attorney does. When the school calls and says, this kid is just a complete wreck, the family has no ability to access perhaps these other services. They're not savvy enough to plug into the system that way. And so the next thing you know, that high needs kiddo is before that court on a CHINS petition. You know, if you look at the dollars that are spent, maybe you have less than 5 kiddos on your caseload, but you're spending $500,000 on those kids and out-of-home placements. So I think the takeaway was you've just got to have those services and those funds diverted to your communities to try to meet them there. I know that that's what with Families First Prevention Services Act and their DFS's Wyoming Home Matters program, that's the whole trend, is that's what they're going to try to do. You know, I was looking at the data, and the juvenile filings are pretty level over time. They were at a high of almost 800 in 2016. For 2021, they're less than 600. And CHINS cases are always under 200 statewide. The lowest was 2020, we had 116 CHINS cases. Doesn't sound like a lot, but when you look at those dollar figures attached to them, these aren't kids that are just truant. These are severely mentally ill kids that don't have services in their community. And so they're being placed in these residential treatment facilities and sometimes out of state because Wyoming doesn't have what they need. So just from my perspective and my colleagues' perspective, that's what's happening. Just an incredible mental health need for these kiddos, and people are plugging into the services as best they can.
Committee, additional questions? Anything else you'd like to add?
No, sir.
We're just here for questions.
Thank you.
Okay. Thank you. All right, committee. Oh, that public comment. Do any public comment on this topic? Machine.
Mr. Chairman, members of the committee, Donna Sheen with Wyoming Children's Law Center. Promised to be brief, but I do want to point out that we do a lot of work on Chin's cases throughout the state, and I would agree with what everyone says. One of the things I think that has been very helpful is the development of the children's mental health waivers. So, but what we see is that in some jurisdictions, they're not as aware of it, or it isn't working as well. The connections aren't being made. So I do think that some clarification that needs to be explored first would be helpful. But more importantly, the thing that I think concerns us the most at the Law Center is that a Chin's petition, in theory, it seems like it's a parent consenting. But we have been involved in a few cases where it is being used because there is maybe some suspicions that a parent is abusing or neglecting, but there's no evidence. And so what I would say is that there is really very limited or almost no due process rights for a parent in the Chin's proceeding. And so when it is used and a parent is objecting to it, I would encourage the committee to take a look at whether or not the parent shouldn't have some due process rights to defend against the removal of a child from their legal custody in those instances. I think that maybe was an oversight and should be addressed. I would be happy to answer any questions.
Committee? Thank you, Machine. Virtual public comment.
Mr. Chairman, it looks like we lost our virtual commenter.
All right. I'm sure if it's important, it will circle back to us. Okay, any other public comment, virtual or physical, on this topic? You do? Judge Wilking? Can we ask you one more question?
Thank you, Mr. Chairman. Judge, one short question. Nasheen just related this issue of due process for parents in a Chin's proceeding, and I felt it was important to hear the judicial perspective about the level of due process provided for parents in a Chin's proceeding.
Cameron Olson, Representative Washit, in a Chin's case, the public defender's office is appointed to represent the child that's in need of supervision. That child has full rights to demand a jury trial and a speedy jury trial. All of the discovery that goes along with a delinquency case, they have the same rights as a delinquent does. We don't afford delinquent children's parents due process rights. They're obviously able to participate in the hearing. They're parties to the MDTs. They have input on the predispositional reports. We're not shutting them out of that. They're often sitting at council table with their child and their child's lawyer. I guess I would take issue with the idea that somehow I'm placing a child outside of their home, over a parent's objection. That may happen sometime, but that's done with the recommendation of the MDT team, which has a lot of players in it. It's done after a review of a predispositional report. And, if it's just your garden variety chins, that's a habitual truant, it'd be very rare for a child to be placed out of their home, on your initial disposition. Much more likely they're put on probation and told to go to school. If there are family issues and dynamics, or the child's needs are so great that they can't be maintained safely in their home, yes, a judge might have to make an out-of-home placement, which is then reviewed statutorily, very regularly. Reports are sent to the court regularly. MDTs are held every 3 months if that child is out of the home. And so there is oversight, and there's always the ability for the court to revisit that decision. And the court has to make findings that it's in the child's best interest to be kept out of the home, and that the Department of Family Services has made reasonable efforts to prevent that child's removal from the home. I guess if we had unlimited resources, I could perhaps appoint parent counsel, just as I do in abuse neglect cases, to CHIN's cases. But I think that kind of goes to Director Schmidt's point that in a CHIN's case, the focus is on the child being in need of supervision, not parents, what can we do to help you and your rights with this child. When you get to a point where you're in front of a district court judge on a CHIN's petition, it's very serious, and the focus is on the child and not so much on the parents. They certainly have the right to go get private counsel if they want to, but I don't know that procedurally they would be a party to the action and could, cross-examine witnesses and things like that. It's set up just like a delinquency proceeding would be. And I guess I don't understand the difference between a CHIN's case and then a delinquency case in that forum. I wouldn't appoint parent counsel for a kid that's charged with a delinquent act. And that's just my opinion. That's not my conference's opinion. I want to be really clear about that.
Appreciate that. Thank you, Judge. Committee, if your email will have.
Mr. Chairman, my apologies. We do have that person back if you wanted to have public comment.
I was just going to point out that we received an email from Ms. Gilbert with handouts. So I think we could probably take that as sufficient. It's pretty substantial. I assumed she was sending the email around in lieu of her testimony. So with that, I will close public comment. And committee, do you have any further actions? No? All right. Well, Mr. Fuller, do you have anything you need clarified or summarized before we take off?
Mr. Chairman, I don't, but I'm happy to summarize what the committee did today. That's your call, though. I can wait until tomorrow to do that as well.
Why don't we just tomorrow, let's just do a quick few minutes right before we kick off. I know it's late and the Senate is tired. Thank you, Mr. Fuller. Thank you, committee. With that, we'll be adjourned until tomorrow at 8:30 a.m.